Good morning. This is Cindy Tomei, Vice President of Membership Growth and Engagement with the Illinois Manufacturers Association. Welcome to our continuing series on the COVID-19 crisis and how businesses are managing during this very unpredictable time. Today's webinar will cover the latest on the Family First Act, as more direction has been defined since it was enacted, which was only April 1st that it came into play, which I don't know about anyone else, but seems like that was a very long time ago. This is a very long presentation. The presentation itself is 2 hours in length, and then we will have 30 minutes of Q&A. So for those of you on the webinar, the email address that you see in front of you at this moment, ima@ima-net.org. Please send your questions in and we will interject them either during the call or during the presentation or when the presentation comes to its conclusion. Since we have all been managing through this crisis, the number of questions that the IMA has received has really revolved around families first. Since it's been enacted, there has been more direction from the Department of Labor, and this presentation is incredibly thorough. So it is our hope that the questions that you're having as you implement this in the workplace will be answered during this presentation. I'd like to remind everyone that this webinar is being recorded. The webinar and the slides will be available on the IMA COVID-19 resource page within 24 hours after the end of the webinar. And I'd also like to refer you to other resources we have on that page, including updates from our presenter, Scott Cruz, on the Families First legislation, and some of your questions can be answered there as well. So I'd like to thank the members that are participating on this call today. And for those of you who are participating in our webinars and are not IMA members, if you'd like to send your contact information through the IMA email address that's shown on your screen, we'd be happy to reach out to you to make sure you're getting the most up-to-date information during this crisis. I'd like to take this opportunity to thank our speaker today, Scott Cruz from Greensfelder, Hemker Gale. And Scott, I will turn it over to you, and thank you for doing such a thorough job putting together this presentation today.
Thank you, Cindy, and thank you, IMA. Good morning, everyone out in virtual land. Today, we're going to be talking about what's been on the mind and what's really been all over the news for everybody, right, is COVID-19. This has been my world for the past several weeks, 24 hours a day, it seems, 7 days a week. So really just another day in paradise for me here. As Cindy alluded to, the Department of Labor continually keeps sending out additional guidance on this. We would hope that the guidance had come out initially, because our advice changes every time the new guidance comes out. So guidance came out last Friday. Guidance came out also the week on Wednesday of last week. So this presentation is up to date with all the recent Department of Labor guidance as it relates to the Families First legislation. So we've got a lot to talk about here. Let's get going. Next slide, please. And one more slide, please. Okay, so the Emergency Paid Sick Leave Act. For those who don't know, that effective date was last Wednesday, April 1st, 2020. Hopefully that does not come as a surprise to anybody on this call. Who's covered by this? If you are a private employer and have less than 500 employees, so 499, right, and below, you are covered by this. How do we get to that 500 number? That's been a big question a lot of employers have. Who do you include here, right? If we're pretty close to that number, or potentially even over, you include everybody, right? All your W-2 employees, what I've been telling anybody. Anybody who's a W-2 employee is included in that calculation. So we're talking about full-time. We're talking about part-time. Those on leave right now, for example, anybody who's on a voluntary leave, FMLA, or an involuntary, not involuntary, but an employer-mandated leave, you count them as well. Anybody who's a temporary employee, also seasonal employees, anyone who's a day laborer, right? So again, W-2 employee, count them for the calculation as to how to get to the 500 employees. This does not include, however, to the extent you have already laid off individuals or terminated individuals or even furloughed individuals, right? If you laid them off, this is not, those individuals have been already laid off. They do not count for purposes of quantifying getting to this 500 number. Next slide, please. Okay, small business exemption. So this has been a question that many employers have been asking, and the Department of Labor late last week finally gave us some guidance on this. So one thing to note here, even if you do have less than 50 employees, this does not mean that you are completely exempt from the Families First legislation. That's a question I've been getting a lot of. Well, we've got 50, less than 50. This doesn't apply to us. That's not true. There's only one basis under the Emergency Paid Sick Leave Act, and then, of course, the only basis under the FMLA portion that this applies to. So it is not a full and complete exemption, okay? So I want everybody to be aware of that. So let's go through this. How do you know if you do have less than 50 employees, whether you can qualify for this, this exemption? So first basis, of course, have less than 50 employees. Second, and this is the only reason that you can qualify for this exemption, if your employee requests leave to care for their child whose school or place of daycare is closed for reasons related to COVID-19. That is it. If your employee requests leave for any other reason under the Emergency Paid Sick Leave Act, you do not qualify for this small business exemption. Third, an authorized officer of your business has to determine that at least one of the following applies. And this was just new on Sunday. Your officer has to document that determination and has to retain that determination in your files, right? So it's got to be documented. So just essentially write a memo to whoever's making that determination, for example. If it's the president of the company, write a memo to file for each individual who is requesting leave under for a reason related to that their kid or the school is closed or the place of daycare is closed. To the extent you accept or reject that request based on the small business exemption, you have to maintain a record of that. And we'll go through what those record retention requirements are. But the three reasons here. So as long as one of these reasons apply, you can qualify for the small business exemption. The first is that the money that you will be paying toward a particular individual or individuals while they were out essentially exceeds business revenue coming in, right? So money going out is greater than money coming in. First one. Second is that the individual or individuals who are requesting leave, they have a particular specialized skill or knowledge regarding the business that without them being here during this time period, right? So the 10 days if they're full-time employees, it's going to be very difficult for the business to operate, right? So it's got to be someone with specialized skills and knowledge. The third and final reason essentially is a head count, right? That says, hey, if 9 people are applying for this, and if we grant it for 9 people, and we only have 10 people in the company, well, we're not going to be able to operate for the next 10 days if we give these 9 people time off for this, right? So it's a purely head count number. So to the extent an officer of the business makes a determination at least one of these reasons applies, and again, the employee is requesting leave to care for a child whose school or daycare is closed, you could qualify for the small business exemption. Next slide, please. Okay, joint employment. Why am I talking about joint employment here? It's very important, and this is the scenario where this would come up. To the extent you have separate entities, right, that fall under one, let's say, parent corp, and let's say one of those entities has 25 employees, and the other entity has, let's say, 51 employees. And one of the employees who works for the entity who's got 25 employees requests leave to care for his child because school is closed. And the officer the president of the particular entity goes through the determination and says, no, Scott, we can't give you time off because you've got such a specialized skill that without you being here, we're not going to be able to operate. So in essence, using the small business exemption. And I say in response, hold on a second. We don't have under 50 employees. When you count how many employees you have at company B down the street, which I know you guys are, there's common ownership there, there's 76 employees, right? There's not under 50. You don't qualify for the small business exemption, so I should get leave to take care of my child. How does that analysis going to play out? So the Department of Labor in that situation, to the extent that employee files a complaint saying that the two separate entities, or three, however many there are, essentially constitute one single entity, right? Even though they're separate, they're really one single employer. The Department of Labor will undertake the following analysis. And the analysis is going to be based on control. Does one entity, right, have control over the following as it relates to each of the other entities? Does one entity have the ability to hire or fire the employees at all the other entities? Does one entity have the ability to supervise and control the employee's work schedule and conditions at all of the different entities? Does one of the entities have the ability to determine the employees how much they're going to be paid and the method of payment for all the different entities? Does one particular entity maintain a uniform file for each of the employment records for all of the different entities? If the answer to any one of those is yes, you are a single employer, you are not separate entities, right? So you may not qualify for that small business exemption, right? So I want everybody to be aware of that. To the extent there are multiple entities under one single parent corp, you could be facing this particular analysis to the extent an employee tries to contend that you are a single entity and not separate entities. Next slide, please. Okay, so what are the reasons, qualifying reasons for leave under the Emergency Paid Sick Leave Act? So first and foremost, and I want to take some time to talk about what I have in bold here, because I think this reason has been getting glossed over. Over the course of the past several days when I'm talking to my clients, they forget that this is an essential element to any one of these, right? So it doesn't matter if an employee meets any of the qualifying reasons 1 through 6. If they are not unable to work or telework if the employee must be unable to work or telework due to a COVID-19 related reason. If that employee is able to work, if you have work available, and that employee is able to work at home, right, while they're out on this leave, they are not eligible, right? That is an important analysis that you have to undertake each time an employee requests leave under the emergency paid sick leave and the family medical leave portion, right? It's not just as you meet any one of the 6 reasons under the emergency paid sick leave. It is the employee also unable to work or telework due to a COVID-19 related reason? And we'll go through that, but I wanted to highlight that because a lot of the communications I'm having with my clients, that reason is glossed over, and they don't they forget that the individual must be unable to work or telework in addition to meeting the 6 requirements. So let's go through the 6 requirements. So an individual is unable to work or telework due to the first reason: the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. So on Sunday, the Department of Labor finally made clear, because before Sunday, the advice we were giving is that Governor Pritzker's shelter-in-place or stay-at-home order did not constitute a state or local quarantine or isolation order based on prior guidance from the Department of Labor. They did a complete roundabout, and as of Sunday, they've changed their tune, and they have now said that Governor Pritzker's shelter-in-place and stay-at-home order does in fact constitute a state or local quarantine or isolation order related to COVID-19. However, right, and I say however with a bold because it is a however. Because remember, we have that unable to work or telework requirement. So the question is, right, let's say that your company is in fact a non-essential business, right? And you may be completely shut down, right? Or the other scenario is you're not shut down and folks are just working from home, okay? So those are the two scenarios. So the question is, if work is available, right, would the employee be able to work or telework, but for being required to comply with the shelter-in-place stay-at-home order, right? So let's go through an example here. You are subject to the shelter-in-place order, but you have not completely shut down operations, right? Your employees are just working from home. So you do have work available. So the next step in the analysis is the individual, right? Are the people who are at home, are they able to perform that work at home, right? And if the answer is no, they're not, right? And it could be because of their job, right? So you have work available, right? But based on their job, they're unable to perform that work, right? So no work is available for them. So it could be a situation, I've had this a lot come up, where your exempt employees, they're able to work from home, right? But your non-exempt employees, so the press machine operator, can't work from home, right? Because you can't bring the press machine home. In that situation, the exempt employees, right, they're able to work from home. So they would not qualify for this particular basis under reason number one, right? Because they're able to work from home. So there isn't a situation where they're unable to work. Your press machine operators, they also would not be subject to reason number one. And look at the last bullet point here. It says, if no work is available, right? If no work is available, meaning either the work site is completely shut down or the job itself does not lend itself to working from home. Here's my example of the press machine operator, right? So even though you're non-essential business, folks are working from home, if that individual's job does not lend itself to being able to work from home, there's no work available for that person, right? So he or she would not be qualified for this reason. So it's a little convoluted, right? But again, the analysis is subject to the order, yes. Okay, do you have work available? Yes. Okay, next step is, can the employees who are at home, can they perform that work at home? If the answer is yes, your non-exempt employees, for example, not eligible. If the answer is they can't, right, but so there's no work available for them, right? Again, the press machine operator, they're also not eligible under this reason because there's no work. If you completely shut down your work site, there is no work. Again, those individuals are not subject to this qualifying reason. So that is the reason number one. Next slide, please. Okay, reason number two. The employee, again, unable to work or telework. And the reason is because the employee has been advised by a healthcare provider. Very important. The department made clear on Sunday, this has to be, the directive has to be from a healthcare provider, okay? And the healthcare provider, the advice must be that the employee needs to self-quarantine because reasons A and B. The first is that the employee has or likely has COVID-19, right? And that means that the employee has tested positive or that the employee is experiencing symptoms, right? That is more probable than not that the individual has COVID-19. And so that's scenario number one, right? Where your healthcare employer, your healthcare provider says you need to quarantine because you've tested positive or because you're experiencing symptoms. Reason number two is that because the employee is particularly vulnerable to COVID-19. So where I've been seeing this is mom-to-be who's pregnant. And the doctor says you should self-quarantine because you're more susceptible to it. And more to the point, if you were to contract COVID-19, you could put at risk and jeopardize your pregnancy, right? So that is reason number two. If an employee, and this is a question I've been getting a lot, where employees are self-diagnosing themselves and then unilaterally making the decision to self-quarantine, they are not eligible, okay? The only way they would be eligible is if a doctor instructs them, for the two reasons we talked about, that they should self-quarantine. If an individual goes on WebMD, right, that's not a healthcare provider. So if they're self-diagnosing themselves and then unilaterally making the decision to self-quarantine and telling you, I'm not coming to work because I think I have symptoms and I went on WebMD and it looks like I do, so I'm going to self-quarantine myself, the answer is no, you are not eligible. Again, remember, there's the unable to work or telework requirements. The most important part there being there must be work available, right? There must be work available for the employee to perform. The employer, you have to permit the employee to do the work from where he or she is self-quarantining, and the employee is unable to do the work, right? So a scenario here is someone who is at the hospital and bedridden due to COVID-19. You have work available. The employee is able to do it, right? Generally, you're permitting the employee to do it, but they're unable to because they're bedridden in the hospital. That person would be eligible for paid leave under qualifying reason number 2. The converse to that is you have work available, you permit the employee to do work from home where they're self-quarantining, and the employee says, yeah, you know what, just a fever and a cough, I'm able to actually work. That employee is not eligible for paid leave benefits because, again, he or she is able to work, and they have to be unable to work or telework. Next slide, please. Next slide if we can. Okay, there we go. Qualifying reason number 3. So the employee, again, is unable to work or telework due to the employee's, if we can go one back. Okay, there we go. So the employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. I think we need to go one forward again. Okay, yeah, that's the one we need to be at. Okay, so the employee is experiencing symptoms of COVID-19 and, again, most importantly, is seeking a medical diagnosis. So once again, the employee who self-diagnoses and unilaterally makes the decision to self-quarantine, ineligible. The Department of Labor on Sunday recently made clear that for this particular reason, an individual would be eligible, right, and considered unable to work or telework during the particular time period when the employee is taking affirmative steps to obtain a medical diagnosis, right? They're trying to get an appointment to see a doctor and explain, such as waiting for, or attending an appointment for a test to be tested for COVID-19, right? So while the employee is making that, trying to get that tested, or make an appointment to get tested, the Department of Labor has said during that limited time period, that employee is, in fact, we will consider that employee unable to work, right? However, right, that this leave may not be taken without seeking a medical diagnosis. I want to make that very clear because I've gotten several questions from my clients where, again, the employee is trying to self-diagnose and unilaterally make the decision without going to a doctor. That employee is ineligible. Now look at the last bullet point here because this confuses things a little bit. The Department of Labor has said that, so let's say an employee has made the appointment and gotten tested. And now the employee is just waiting for those test results, okay? So that's the scenario. The Department of Labor said that an employee who is waiting for the results of a test is able to telework and not eligible for paid sick leave. Again, if the employer has work available, the employer permits the employee to work from home, essentially where they're waiting for the test results, and the employee is able to perform that work. So how does this confuse things? It confuses things because there could be a scenario where for 2 days, I'm trying to get an appointment, and I finally get the appointment on the 3rd day, right? So Monday, Tuesday, Wednesday, I get the appointment. On Thursday, Friday, I'm waiting for the results of the COVID-19 test. And while I'm waiting for those results, there's work available for me to do at home. My employer permits it, and in fact, I'm able to do that work. On Thursday and Friday, I'm not eligible for leave, for paid leave, right? And so that's what makes this a little convoluted, is that on Monday, Tuesday, and Wednesday, where I am actually trying to get the appointment, go to the appointment, my employer would have to pay me for benefits, pay benefits. On Thursday and Friday, if I'm able to work from home and am working from home, the Department of Labor said I am not able for benefits for those 2 days. So again, it's a little tricky on how we're making and how we're paying the employee, but this is how the Department of Labor has structured it. So this is how you have to implement it. And then, of course, once the employee gets the test results, there could be a scenario where it reverts back to number 2, right? So and this is why it's even more convoluted. So I'm make an appointment. While I'm waiting to make an appointment, I get paid sick leave. While I'm waiting for the test results, I'm able to work from home. I don't get sick leave. Once I get my test results, they come back positive. My doctor tells me to self-quarantine. I get paid benefits as well, right? Because the reason reverts to number 2. So, we've got to be careful here how we're structuring this, particularly for this reason, number 3, because again, a little convoluted, right? Where there's certain days we're going to have to pay, certain days we're not going to have to, and then we're going to pick up again once the test results come, and if it's positive, and the doctor tells the employee to self-quarantine, we're paying again, right? So again, a little convoluted, but that's how the Department of Labor is structuring it. Next slide, please. Okay, reason number 4. The employee is unable to work or telework due to the employee having to care for an individual who is subject to a quarantine order, so Governor Pritzker's shelter-in-place order, or has been advised by a healthcare provider to self-quarantine. Now, the question is, who's an individual, right? Is it anybody? It's not anybody. The Department of Labor has defined it as follows. An individual means an employee's immediate family member, right? It also means a person who that employee regularly lives in the employee's home. In other words, a roommate, right? Third, or a person whom the employee has such a relationship that it creates an expectation that your employee would care for that person if he or she were subject to a quarantine order. So there's 3 essentially under this individual. There's 3 potential people, right, who this could qualify, right? Immediate family member, someone who's not an immediate family member but who lives in your home, the employee's home, a roommate, or not an immediate family member, not someone who lives in the employee's home, but someone who that employee is so close with, right? A best friend, for example, that there is an expectation that that employee would care for that person if he or she were quarantined, right? So that's how individual is being defined. This does not include, right, anybody. It's not anybody, right? If the employee has no personal relationship with that person, or there is no expectation that the employee will care for that person during the quarantine or self-quarantine period, that individual is ineligible. Again, remember the unable to work or telework component here, right? You have work available, and you permit the employee to work from home, and the employee is able to do work from home, not eligible. Not eligible. If have work available, you permit the employee to work from home, and because the individual must care for this person for 12 hours a day, right? 7 days a week, 12 hours a day, the individual says, I can't work, right? Because I need to care for this person round the clock. That person would be eligible because they are unable to work or telework. So again, be very careful with that one. Next slide, please. Reason number 5, the employee is unable to work or telework because the employee is caring for a son or daughter whose school or place of daycare has been closed, or the child's care provider is unavailable due to COVID-19 precautions. So I've been getting this question a lot from my clients because employees are trying to abuse it. Now, let's be very careful here, and let me go through this very carefully in terms of when an employee is actually eligible for this particular reason. the Department of Labor has made it clear that there must be no other suitable person at home, such as a co-parent or a guardian, who's able to care for the child during the period of such leave. So, in this scenario, mom's home, dad's home. Dad applies for leave. Dad is not eligible at all because mom's home. It does not matter if dad says, well, mom's working from home though. Does not matter. Mom is home. Under the Department of Labor's rationale, there is another suitable person, a co-parent, who is able to care for the child. In that scenario, two-parent household, both parents are home at the same time. Not eligible. So dad applies and said, well, mom is working, but mom's business is essential, so mom's going in the office every day, right? So I'm going to be the only person who's able to care for our kids. Okay, eligible, right? But we'll get to that unable to work. So again, be very careful with that. If there is another parent home, it doesn't matter if that employee is also working from home, the individual is ineligible, right? Unless you choose to give it to that person. So the Department of Labor has made clear that the employee requesting leave must be the one who is actually caring for the child, right? So dad says, well, mom's home too, so I'll watch the kids for a couple hours, and then mom's going to watch the kids. No, it's not how it works. Dad is ineligible because mom is also at home. Also, remember, the unable to work or telework. So this also tripped up some of my clients the past couple of days, right? So dad says, let's say, for example, the kids are 12 and 13. And dad says, hey, I'm going to be the only one at home, right? Mom is essential business. Mom's working every day from the office, right? At the work site, not a home office. But dad says, hey, you know what? There's work to be done, and I'm able to work from home, so I'll be working during this time period as well. Unfortunately, dad is now not eligible because, again, the employee must be unable to work or telework, right? So if dad says, yeah, there's work to be done at home, my job allows for it, I'm going to be working while I'm watching our 12 and 13-year-old. Dad is not eligible, even though dad's the only parent who's at home. Now, another scenario is it's a newborn, right? And dad says, well, the newborn is 8 months old, right? And so obviously I need to care for and watch the 8-month-old essentially around the clock. Now, this can be tricky too, right? Because at some point, the newborn is going to go to sleep. So what if the dad says, well, I'm able to work while the newborn is asleep, right? I'm just not able to work while the newborn is up. So in that scenario, legally, right, dad would not be eligible for benefits while he's working when the newborn is up, when the newborn is asleep. So unless you allowed for that. So it could be a scenario where you say, well, when the newborn's asleep and you're working, you're not eligible. When the newborn is up and you're unable to work, you are eligible. So again, very tricky here in terms of how we're implementing this. Again, you can say, okay, you've got a newborn, we're just going to give it to you. You can certainly do that, but you're not required to because, again, the person must be unable to work or telework for the COVID-19 related reason. So, there isn't a one-shoe-fits-all approach here, is what I'm telling all of my clients, right? These are scenarios where they're case by case, that each individual scenario presents itself with certain facts, as we just alluded to with that past hypothetical. Next slide, please. Okay, so we're still on qualifying reason number 5. So the one question that finally got answered by the Department of Labor, everybody was asking, is grandma a child care provider? The answer is yes. The Department of Labor finally made its decision and made it clear, I should say, on Sunday that grandma is a child care provider. So to the extent grandma was the only one watching the kids, right, and grandma now feels uncomfortable watching the kids because she may be susceptible to COVID-19 and she does not feel comfortable watching the kids because she doesn't want to, to the extent she has it or doesn't know that she has it, doesn't want to give it to the kids, grandma is now unavailable, right? So in that scenario, grandma's unavailable. And one of the parents says, well, grandma's unavailable. Mom's working from home. Mom's working at the office. So dad says, I'm the only one now who's able to watch the kids, right? Dad could be eligible to the extent he's unable to work from home, to the extent he is unable to work from home. Grandma's unavailable, mom and dad are both at home, right? In that scenario, neither of the two parents, so dad's asking for leave, grandma's unavailable, both mom and dad are home. Dad is not eligible because mom is home, another co-parent is there, a suitable person is there to watch the kids. But the point being, there's a lot of question in terms of whether grandma is a care provider because obviously they're not paying grandma. Grandma isn't following the licensure requirements for a daycare center. The Department of Labor said it doesn't matter. Grandma is a child care provider. Place of care. Place of care means any physical location where care is provided for the employee's child. So this could be, again, at different schools. It could be at home, right? It could be grandma's home. Summer camps, summer enrichment programs, to the extent that continues on through the summer. Now, for a child, in terms of a son or daughter, the child must be under the age of 18, right, for this to apply, except if you have a child who is 18 or older and is incapable of self-care. So if you have a child, a disabled child who's 18 or older and incapable of self-care, then you could qualify as well. One thing to note, and we'll get to it under the notice requirements, the IRS, in terms of the documentation it is requiring for those tax credits, has made an additional requirement that says if the child is over 14, then the parent has to identify and answer the question of why you need to watch the child, right, and unable to work for a kid who's over 14. So if your child, essentially saying that a child who's over 14 should be able to watch him or herself without mom and dad being present. And so to the extent your employee, right, the kids are 14 or over up to 18, in that scenario, in order for you to get the tax credits, the form that you are completing, right, we have created a form for our clients. This question is on that form. It says that the employee must answer the question of what specific reason is there, right, that the individual, the kid who's essentially, you have to watch a child who's over 14. And it can't be, or maybe it can, depending on how the Department of Labor is looking at this, because I want to be home, right? There must be some specific reason that the employee must identify on why the child who's 14 or over needs to have mom and dad home to watch him or her. So again, that should be on your form. It's important for us to realize that and understand that because IRS has made that a specific requirement now in terms of you being able, as an employer, collect tax credits if the child is 14 or older. Broad definition of son or daughter, right? It's any biological, adopted, foster child, stepchild, legal ward, or if you're standing in local parentis. What does it mean if schools are closed? That question has come up where my son's high school is closed, but they're taking, all their classes are now online, right? Is the school still closed? The Department of Labor answered that question, and the answer is yes, right? So long as the physical facility is closed, so long as the physical facility is closed, this means that the child's school is closed due to a COVID-19 related reason, even if some or all of the instruction is being provided online, right? So the question is the actual school closed? The answer, yes, okay. Again, doesn't matter if the kids are doing the classes online or not. Next slide, please. Okay, the sixth and final reason. The employee is unable to work or telework due to the employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and the Secretary of Labor. So this has been a big question I've been getting as well. On Sunday, the Department of Labor finally answered it and said, as of today, as of Sunday, and that hasn't changed as of today, there is no other condition other than COVID-19. So there is no other condition that would qualify for leave other than COVID-19. Okay. Now, why we separated these in terms of 1 through 6, the reason I did that is because how much you have to pay the employee is determinative on what reason they qualify for. So if they qualify for reasons 1 through 3, remember that's the shelter in place, that's they have to quarantine because the doctor told them to, or that is they're experiencing symptoms and seeking a medical diagnosis, the most that employee is entitled to is $510 per day and capped at $5,110 in the aggregate for each employee, right? Not aggregate total, each employee total, not total regardless of how many employees taking it. For reasons 4 through 6, and that is an individual needs to care for someone who is self-quarantined or who a doctor told to self-quarantine, or because they need to care for their child whose school or place of care is closed. That is capped at $200 per day and $2,000 in the aggregate for each employee. And we'll talk about in the next slides coming up how we actually calculate how much an employee gets. Next slide, please. Okay, so again, I want to highlight this because it is very important, right? What does it mean to be unable to work, including telework? Again, remember, it is a two-step analysis when an employee files, applies for leave, right? 1, do you qualify for any of the 6 reasons? Yes or no? If yes, then your analysis is this. Are you unable to work or telework for a COVID-19 related reason? And employees, again, are unable to work if you have work available for that employee. You permit that employee to perform that work at home, and the employee is unable to perform that work, then they would be eligible. If you have work available for that employee to do, and the employee is unable to, and the employee is able to perform that work, right? He or she not eligible. Now, a caveat to the unable to work is if you have work available, but you have work available for other employees, but based on that employee's particular job, right, there is no work available. Again, I keep using the press machine operator, right? The press machine operator can't take that press machine home. So you don't have work available for that employee to do at home. In that situation, the press machine operator is not eligible, right? Because you don't have work available for that employee to do at home, right? So that is the analysis. Again, I want to highlight this because it seems that this reason is getting glossed over, and employers are just accepting or rejecting based on whether or not the employee qualifies for reasons 1 through 6. And there's another step that you have, another question you have to answer before you determine whether or not someone is actually eligible. Next slide, please. Okay, how much leave do qualifying employees get, right? So if they're eligible. Full-time employees, they get, so full-time employees, that's defined as they work 40 or more hours per week. It's capped at 80 hours total. It is capped. They can't double dip. What do I mean by that? So let's say that I qualify for reason number 2, right? Because my doctor has told me to self-quarantine. I'm a full-time employee, so I get 40 hours per week. I exhaust my 80 hours. At the end of those 80 hours, I tell you, hey, it looks like I qualify for reason number 5 because my child is, school's closed, and my wife is working, but she's working at the office, and there's no one else to take care of our child, right? Now, that person would qualify for FMLA, but to the extent they, so let me use a different example. That's not a great example. So I exhaust my 80 hours, and then I tell you that I now need to care for, so qualifying reason number 4, that I exhaust my 80 hours, and then I tell you, well, my wife now is experiencing symptoms, and her doctor told her to self-quarantine, so I want to take an additional 80 hours. The answer is, unfortunately, no, because I've already exhausted my 80 hours, and that's all I get, right? So once I exhaust my 80 hours, I don't get another 80 hours, even if I qualify for any other basis under the emergency paid sick leave. So that's what I mean by you can't double dip. Part-time employees, now many employers have their own definition for part-time employees. this is the definition you have to be worried about because this is how the Department of Labor is defining part-time employees. A part-time employee is anybody who works less than 40 hours per week, right? 39 and fewer is considered part-time. Not 20 or fewer, not 25 or fewer, not 35 or fewer. It is less than 40, meaning 39 or less, right? So for part-time employees, how do we determine how many hours they get? That is determined based on the average over a 2-week period. This includes overtime. So it will always be capped at 80 hours. But let's go through an example. So someone works on average 25 hours per week, right? That individual would be entitled to 50 hours total under the Emergency Paid Sick Leave Act. Let's say, use another example. An employee normally works, right? At least when they were hired for 25 hours per week. But over the past, let's say 6 months, right, they're working overtime and up to 45 hours a week, which includes overtime. So 45 times 2 is 90. Do not fret. You're not having to pay that employee 90 hours, right? It's still capped at 80. But I wanted to use that example because I have in here the Department of Labor includes that the average includes overtime hours, right? So just because that person worked 25 hours, or that was the expectation, if over the past 6 months, right, I worked on average 45 hours and 20 of those were overtime, that needs to be included, right? So I would get that full 80 hours because you have to include the overtime hours. The other example I want to talk about is this. So I've had some clients who have reduced their employees' hours during the month of March. So someone who was ordinarily working for the past, let's say, 6 years, 40 hours, as of March 15th, they're now only working 30 hours. You cannot base it on what you did on March 15th, right? That employee was always working 40 hours. So the average is how many hours that employee is working on average over a 2-week period. That 2-week period should not be from March 15th forward. It should be from the date that employee was hired. And if that individual always worked 40 hours, then they get 80 hours, not 60 hours. Variable schedules. So variable schedules is if an employee works different hours each week, right? So an employee works 15 hours one week, 20 hours another week, 30 hours the following week. How do we determine how many hours that employee gets? So the Department of Labor has indicated that we use 14 times the average number of hours that the employee was scheduled per day over a 6-month period, ending on the day the employee takes sick leave. So this example, if an individual requested leave on April 1st and they had a variable schedule, you would go back 6 months from April 1st and take an average of how many hours I worked per day over that 6-month period. And if I worked on average 5 hours per day over that 6-month period, you would take 14 times 5, that's 70 hours, right? That individual would be entitled to 70 hours total, right, for the paid sick leave here, right? Because that's how many hours is 14 times 5, 70 times total. It's 14 times the average number of hours the employee worked each day over that 6-month period. So that's how you would determine that for a variable schedule. Remember, 14 times the average number of hours worked each day over the 6-month period. For newer employees, what is the reasonable expectation at the time of hiring? So you hired me 3 weeks ago. You told me that I could expect 30 hours per week. That's my reasonable expectation. I would be entitled to 60 hours in terms of the cap for paid sick leave. Next slide, please. All right, so for the amount of leave, this is important too because this has come up already for some of my clients. If the employee no longer has a qualifying reason for taking paid sick leave, before actually exhausting the paid sick leave, the employee can take any remaining leave at a later time if another qualifying reason occurs until December 31st, 2020. So let's go through an example. So an employee, let's say they are on April 1st, They've requested leave because they claim to be experiencing symptoms. And they tell you, I'm experiencing symptoms and I'm going to go seek a diagnosis, right? So that was April 1st. And then let's say on April 6th, which is Monday, the employee called you and said, you know what, I was trying to make an appointment, but lo and behold, I woke up today and I no longer have any symptoms and I feel fine, right? So that employee used essentially, let's say they're 40 hours a week, right? They used April 1st, 8 hours, April 2nd, 8 hours, April 3rd, 8 hours. They've used 24 of the 40 for the week and 24 of the 80 that he or she would be entitled to. So that individual, right, still has whatever 80 minus 24 is, that many hours left up through December 31st, 2020, if he or she decides to cut off the paid sick leave and say, I'm going to come back to work, right? Now, he could use that remaining time period anytime through December 31st, 2020, if another qualifying reason occurs, right? So the employee says, let's say sometime in June, and unfortunately, if this is still going on, and the employee says, well, my kid's school is closed, right? So I want to take the remaining time I have, like I didn't use the full 80, the employee can do that, so long as he meets those eligibility requirements. So I want everybody to be aware of that there could be a situation where someone does not exhaust the full 80 hours and still has some time remaining. They may be able to use that time remaining through December 31st, 2020, if they qualify for another reason. If an employee unless the employee is teleworking, right, which permits intermittent leave, and we'll talk about that. Once an employee begins taking paid sick leave for qualifying reasons 1 through 6, the employee must continue to take paid sick leave each day thereafter, right? Unless what we just talked about, right, the employee uses the full amount of paid sick leave, or the employee no longer has a qualifying reason for paid sick leave. There is an exception here that we'll talk about. If an employee is at your work site and their qualifying reason is number 5, which is that their child or the child's school or place of daycare is closed, you could, if you agree, choose to enter into an intermittent leave schedule with that employee, where that employee would not have to take 10 consecutive business days off. That's only for reason number 5, and again, you're working at the work site, and if you agree. And we'll go through an example in the next couple of slides. Next slide, please. So intermittent leave, gotten this question a lot. Are employees able to take intermittent leave? The answer is it depends, right? So the Department of Labor has made clear that unless you, employer and employee, agree, right, that agree to an intermittent leave schedule, the employee cannot take intermittent leave. As it relates to teleworking or working from home, right, the employee can take intermittent leave for any of the 6 reasons, right? Any of the 6 reasons, so long as you, employer, agree to it. I had a client the other day who was pulling her hair out because she said, I can't believe we've got to give each of these employees that's requesting intermittent leave, and I don't know what we're going to do. This is going to be a nightmare to schedule all of these employees. And I said, what are you talking about? It's not a nightmare at all, because you have the ability to say no, right? The inmates do not run the asylum, right? You, as an employer, you have the ability to say no. So it is not a situation where the employee says, I'm going to do this, right? It's a situation where the employee says, may I take intermittent leave, right? And you are the final decision maker, employer. You're the one who says, yes, you can, or you're the one who says, no, you can't. And if you say, no, you can't, the end. The employee does not get to take intermittent leave, right? So for teleworking, again, the employee, if you agree, can take intermittent leave for any of the 6 reasons, so long as you agree. And the intermittent leave schedule, right, you the employee can agree on an intermittent leave schedule for any increments, right? Again, so long as you agree. So I have an example here where the employer and employee agree on a 90-minute intermittent leave schedule, 90-minute increments. So the employee is teleworking from 1 to 2:30, takes leave from 2:30 to 4, and then after 4 returns to teleworking again. Remember, you have to agree to this first, right? If you say no, the end, no intermittent leave schedule. Next slide, please. So intermittent leave in the workplace, right? So let's say you're an essential business. Let's say that your employees are working from the office, right? And one of your employees asks for and qualifies for paid sick leave for any of the reasons, 1 through 6, right? You cannot take, this should be instead of 1 through 5, it should be 1 through 4 and then 6. Employees cannot take intermittent leave for qualifying reasons 1 through 4 and 6. Those have to be taken in full day increments. However, an employee can take intermittent leave while they're working at the work site for reason number 5, right? Again, that's to care for a child whose school or place of care is closed. But only if, again, you agree to it, right? The employee cannot say, this is what I'm going to do. Again, it's, may I do this, right? You have the ability to say no. If you say no, the end, the employee does not get intermittent leave. So here's an example. Let's say the employee's child is at home, right, and you come up with an intermittent leave schedule as follows, where the employee takes paid leave on Monday, Wednesdays, and Fridays, and then on Tuesdays and Thursdays, they're working back at the work site. You can do that, right, so long as you agree to it, right? That's the important key piece. The important piece here is that you, the employer, have to agree to this intermittent schedule. Again, when they're working from the work site, right, reasons 1 through 4, no. Reason 6, no. Reason 5, yes, so long as you agree. Next slide, please. Okay, how do we determine how much individuals get paid? So it depends on what reason they qualify for. So reasons 1 through 3, again, reason 1 is the shelter in place. Reason 2 is doctor says to self-quarantine. Reason 3 is I'm experiencing symptoms and I'm going to go seek a medical diagnosis. If any of those, for any of those 3 reasons, we have to pay the employee the greater of being the key, the operative term here, the regular rate of pay, right? And regular rate of pay is defined as follows. So it includes base pay, it includes tips if you're in the hospitality, it includes non-discretionary bonuses, it includes shift premiums, it includes commissions, and any other incentive compensation that an employee can earn during any individual single work week. So I want everybody to be very clear about this, right? Regular rate of pay, again, if someone just gets $18 an hour, that's your regular rate of pay. If someone gets $18 an hour, right, but they're also entitled to commission, it's base pay plus that commission. And it's very important that you make sure you factor that commission in. Plaintiffs' attorneys are chomping at the bit to sue you. They've already made that clear. And I think this is going to be the reason and how they're going to get at you, because you have miscalculated the proper rate of pay. If you aren't including everything in the rate of pay that the employee is entitled to, then the employee is not being compensated accurately, right? If they're not being compensated accurately, they're going to sue you, right? And you don't want that. So make sure you are properly calculating the regular rate of pay. So again, it's there for reasons 1 through 3, they get their full regular rate of pay. So if I'm making $18 an hour, I'm a full-time employee, it's $18 an hour times 80. That's what I'm entitled to. Again, the greater of the applicable minimum wage, right? So hopefully everybody is paying folks above minimum wage, so this won't be an issue, right? For FLSA minimum wage, right, $7.25. Locally, state at $8.25. If you're in Chicago, it's $13 an hour, right? So if I'm making 18, that's obviously above all of these minimum wages. That's what I'm going to be paid, $18 an hour. Now, that greater of determination is going to come into place here when we're looking at for when an individual qualifies for reasons 4 through 6. And reasons 4 through 6 are as follows. Remember, 4 is to care for someone who is under a self-quarantine order. 5 is your child is at home due to the school or place of care being closed. And then 6 is there's some other condition, but again, no other conditions out there yet. For those reasons, so let's focus on 4 and 5. it is 2/3, the greater of, 2/3 the individual's regular rate of pay or the applicable minimum wage. Now, we need to be careful here. If you're paying someone close to or at minimum wage, so let's say you're in Chicago, and you're paying someone $13 an hour. Well, 2/3 of $13 an hour is going to be less than 13, right? So the default is you're paying that person $13 an hour because it's the greater of their regular rate of pay or the applicable minimum wage. So be very careful here, right? If you're paying someone close to the minimum wage and 2/3 of that amount gets you below minimum wage, you have to pay the greater of. The greater of would be minimum wage. Now, you can agree if the employer and the employee can agree to permit the employee to supplement paid sick leave or FMLA leave with employer-provided paid leave up to the employee's normal earnings. So, what do I mean by that? So, an individual is only, let's say they normally make $14 an hour, right? And 2/3 of $14 an hour, 2/3 brings you to a number below minimum wage. That individual, you're in Chicago, you're paying that person $13 an hour. So there's a $1 differential. If that person has existing vacation or paid leave, they can request, and if you agree, you can come up with a formula to say you can use a portion of your, let's say, vacation pay to get you that $1 an hour, to get you that $1 additional hour to get you up to 14, right? Because that's your normal earnings. Again, you have to agree to that, though. So just want everybody to be aware of that because that situation will come in when you're doing the 2/3 regular rate of pay and an employee wants to earn what they're normally earning, right? And if they have leave available to them, so long as you agree, they could use a portion of that leave to get them up to whatever they were normally earning. Next slide, please. Okay, so employees are immediately eligible as of April 1st. There is no waiting period here. This paid leave is in addition to any other leave provided by employer. So let me take a minute here to talk about this because this question has come up. I've gotten the questions from a lot of clients that are saying, we don't offer any kind of leave, right? We don't offer vacation. We don't offer any paid leave. Are we still subject to the Act's requirements? And the answer is yes, you are, right? Yes, you are, because this is mandated. It doesn't matter if you offer vacation. It doesn't matter if you offer sick leave. The law says if an individual qualifies for one of these reasons, right, for reasons 1 through 6, they get this paid sick leave, right? Now, what does it mean by in addition to any other leave? This means, for example, on April 1st, if someone has 10 days of PTO still remaining and they qualify for reasons 1 through 6, they'll get paid for 10 days, right, because at the 80 hours, and then if the employee says, you know what, I want to now use my additional 10 hours of PTO, they'd get that additional 10 hours of PTO. We cannot require, under the Emergency Paid Sick Leave Act, FMLA is different, we cannot require that an employee exhaust their existing leave prior to us paying under the paid sick leave portion. So using that same example, let's say someone has 5 hours or 5 days of PTO, right, on April 1st, and they qualify for reason number 2. You as an employer cannot say, well, Scott, it looks like you have 5 hours of PTO, so exhaust those 5 hours first, and then once you're done, then we'll pay the additional time, the additional 40 hours, right? But the first 40 hours, you're going to use that with your own PTO. You can't do that. You cannot require that I exhaust any available time that I have prior to you paying out or me being eligible for any of the leaves. There's no payout of this on termination. So let's say we're in June, you terminate an employee, and the employee says, you know what, I never used my available 80 hours. Too bad, right? You're not getting it. We don't have to pay you on termination. Another example, so we need to be concerned with no carryover to next year. So let's say, using my earlier example, the employee only uses 24 of the 80 hours, right? Come December 31st, 2020, the employee says, hey, not a big deal. I didn't use them. Just carry over it to January 1st, 2021. No, there is no carryover provision, right? This Emergency Paid Sick Leave Act, it expires on December 31st, 2020. It is a use it or lose it. If the employee has not used it, they lose it. Next slide, please. Employer prohibitions. Just like with anything, right, we cannot discriminate or retaliate. Be very careful here. I say constructive notice. What do I mean by that? Let's say that an employee tells you, right, they intend to apply for paid sick leave. They haven't done so yet, but I'm going to do this. And the next day you fire that employee, right? You're going to be facing a retaliation lawsuit before you can even blink an eye, right? Constructive notice means that you have knowledge that the individual is going to or has engaged in protected conduct. Protected conduct is me telling you that I intend to apply for leave under the Paid Sick Leave Act. So again, be very careful to the extent you are terminating folks. Do not unilaterally single someone out who a day or 2 days ago, right, told you that they intend to take leave, right? Not the best move on your part. How you get around that, of course, right? You terminate several people, right? Now, and that individual could be included in there, but hopefully you're not doing it to retaliate. Hopefully you're doing it because there's just a lack of work, right? But be very careful about that. The Department of Labor has also said that employers cannot require employees who are seeking leave to find a replacement for their shifts. So if I'm working the 9 to 3 shift generally, and my employer is essential, which means we're open, my employer can't tell me, Scott, before we give you this leave, you need to find someone to cover that Monday through Friday 9 to 3 shift. Can't do that. That onus, that burden is on you, the employer. This is enforced under the Fair Labor Standards Act, which means what? It means we can be sued. It means employees can sue us. It means they can get lawyers who will file lawsuits against us. Those lawyers, if they're successful, can get their attorney's fees, right? The Department of Labor can sue us. If we are violating the act, the employee is subject to back wages, liquidated damages, and attorney's fees and statutory penalties. Those are steep, folks. As of February 19, 2019, the statutory penalties are steep. If you are not giving someone, let's say you miscalculated the regular rate of pay, and then you didn't provide that individual with all the money he or she was entitled to, and you get sued, the statutory penalties are as follows. It's 5 times that amount for each month you're not paying it, right? On top of that, it's 3 times that amount. On top of that, right, the Department of Labor has their own individual penalties. So we're talking about a lot of money here, right? So again, I brought up that regular pay, and I want to emphasize that because that's where I think the trap is for employers. If you are not properly calculating someone's rate of pay, you will be sued. And it's not going to be pretty because you're going to owe a lot of money. So make sure you are properly calculating that rate of pay in terms of what someone is entitled to. Next slide, please. Okay, employee notice requirements. So this has been subject to some confusion. Not here at Greensfelder, though. We believe in terms of what our advice is, in terms of what we're telling folks. So this is what we're telling everybody. To the extent your lawyer is telling you otherwise, you can certainly choose to follow your lawyer's advice. But this is what we're telling folks, and I'll tell you what I mean by that at the end. So it is clear there is no gray area that an employee is required, right, to provide appropriate documentation, including the following when they apply for leave. They're supposed to provide the employee's name, right, qualifying reasons for leave. The third one being very important in my eyes, a statement that the employee is unable to work, including telework, for that COVID-19 related reason. And the date or dates for which leave is requested. Now, the confusion here has been because if you look at the Department of Labor's regulations, if you read them narrowly, which some folks are doing, a narrow interpretation says that an employer cannot require any type of other supporting documentation, i.e. a note from a doctor, right? But you can't read it narrowly. If you look at the particular section, I think it's 826.40, I believe. I can confirm that though, but the particular regulation that talks about this in terms of documentation, read it carefully, because it also identifies and refers to the IRS guidelines and the IRS frequently asked questions. And those need to be read in tandem. The reason I say that is because it is clear. The IRS has made it clear. Their frequently asked question, number 44, if you go to that question, the IRS says, in order for you, employer, if you qualify or employer want the tax credits, you can require all appropriate supporting documentation for the leave. We have interpreted that all appropriate supporting documentation to mean, right, until the IRS says otherwise, that you can request the doctor's note. And you should, right? Think about that, right? In terms of an employee is telling you, I got a diagnosis, are you going to take the employee's word for that, or do you want the doctor's note? If the employee is telling you, my doctor has told me, instructed me to self-quarantine, right? Are you going to take the employee's word, or do you want the doctor's note? You want the doctor's note, right? And so our advice is that employers, you can require and you can request that the employee provide appropriate supporting documentation. And again, that recommendation is based on the IRS's guidelines, and you have to read them in tandem. You can't just read the Department of Labor, because that section that talks about documentation specifically refers to the IRS's guidelines, right? And the IRS's guidelines and their FAQs, in no uncertain terms, say that an employer can request supporting documentation. Supporting documentation is a doctor's note. So that is what we can require of employees. All of this, and then in addition, supporting documentation as well, i.e. the doctor's note. Next slide, please. Okay, so what are our notice requirements? So the Department of Labor published the required workplace poster. That is in English and Spanish. If you don't have that, Google Department of Labor required workplace poster COVID-19, you'll get the link. That must have been posted in the workplace by April 1st, so as of last Wednesday. If you've got folks who are working remotely, the Department of Labor has recommended, i.e. you should email those employees that poster, right? If you've got an intranet, the Department of Labor has recommended, i.e. mandates, that you post that poster on the intranet as well. Even if you have under 50 employees, you must post, because remember, that small business exemption is not a complete exemption. It's only if the employee requests leave to take care of his or her child, because school or daycare is closed. So if you're under 50, you still have to post. And then importantly here as well, you must provide all new hires through December 31st, 2020, a copy of that poster, right? So in your onboarding materials, make sure that is now included in terms of what you're providing to any new employees who you hire through December 31st, 2020. Next slide, please. Okay, and I think we were going to stop here to take questions.
Okay, Scott, you need a breather.
I'm good.
Yeah, we do have a series of questions, and we'll have some definitely at the end as well. And some of these do go back to the beginning of the presentation. When a company is counting their employees, what is the procedure for someone who receives a 1099?
So if now be very careful here, because I'm getting this question a lot too. Make sure they are a true independent contractor, right? If you are misclassifying them, they're an employee, and so they're counted. If they're a true independent contractor, then they don't get counted, right? Because they're not employees. So I'll just digress for 1 second. If you have an employee who is doing work integral to your company, right? They're not an independent contractor, they're an employee. So be very careful about that in terms of whether or not you're misclassifying someone as an independent contractor. Because if you are, that person should be included as an employee, and that certainly is going to muddy your determination as to whether or not you meet that less than 500 employees. So take a step back to make sure they're truly independent contractors. A true independent contractor, for example, is if my law firm hires a web design company to redo our website. That is an independent contractor, right? It's not an employee who is a lawyer who is giving legal services who we classify as an independent contractor. That person is a employee because we're in the business of providing law, and that person is in fact doing law. So just make sure that person is truly an independent contractor. But to answer your question, only employees, W-2, not 1099 to the extent they're truly 1099s.
All right. Next question. This has to do with how you were interpreting joint employer. So many of our manufacturers have temporary employees, and this question's come up a lot. How are they included in the count?
So it depends on how you're defining temporary employees. If they are not your employees, then you don't count them, right? So to the extent, again, I don't know if the question is that, hey, we're using a staffing company, and the staffing company is providing us with individuals. Do we count those individuals? And the answer is, well, it depends. What's your relationship with that staffing company? Look at your staffing company agreement. Hopefully, in that agreement, there's language that says these folks are not our employees. They're your employee staffing company, right? So if that's the case, you're not counting them because they're not your employees. So be very careful in terms of who's the employer there, right? That's where this joint employer comes in. If you have the ability to hire, fire, discipline these staffing company employees, you're their employer, right? That's how the department is going to look at that. The Department of Labor is going to look at that. And so those employees will be considered yours and will be counted, right? So again, that question, without knowing more, I'm assuming they mean a relationship with a staffing company. And hopefully in your agreement with the staffing company, you've made it clear, or the agreement makes it clear that they're not your employees, those are staffing company's employees.
Okay. This goes to reason number 5 regarding the child care issue if school is closed, which of course it is. This has come up a couple times. What if an employee is a second shift employee or a third shift employee? Company is an essential business, so they are still operating, but during the day hours, this employee is the only source for child care. Are they eligible to take leave?
So yes, if they're the only source for child care, again, so long as, right, that individual is unable to work or telework from home. So sole source of child care, yes, but again, that does not end the analysis, right? You still have to determine, is there work available for that employee to do? And if the answer is at home, if the answer is no, based on his job, right, we have no work available for him to do, then it doesn't matter if he's the only source for parenting, right? He is not eligible unless you agree to make him eligible. So, I'm making a little convoluted, but that's how you have to undertake these analyses. So yes, if he's the only source, yes, but again, the analysis doesn't stop there. Is that individual unable to work or telework from home? So that's the other question you have to ask yourself. You have to undertake.
And what about for that same reason, number 5, if the two parents work for the same company? Can the parents alternate who's taking leave? One takes it 1 week, the other takes it another week. I'm sure it's the assumption that they cannot take it at the same time.
Correct. The assumption is they cannot take it at the same time. That would be a situation where you, employer, agree to an intermittent leave schedule. So remember in the slide I had an example where two parents, and let's say, dad says, I'm going to go to the plant on Monday, Wednesday, Friday. Mom, you're going to watch the kids Monday, Wednesday, Friday. Then dad says, I'm going to watch the kids Tuesday, Thursday, and mom's going to go to the plant Monday, Wednesday, Friday. So if you choose, right, employer, you agree to an intermittent leave schedule like that, you can do so, right? If not, then dad would have to take 12 weeks, and then mom would have to take 12 weeks, right? Or dad can take 1 week, come back to work, mom takes 1 week, come back to work. Again, entirely up to you, but you as the employer are the final decision maker on how that's handled.
Okay. All right. Why don't we get back to the presentation? And I know we'll have more questions at the end.
Okay. So EFMLA and the family medical leave portion of this. Effective date, April 1st, 2020. Again, last Wednesday. Covered employee. So be very careful here. Ordinarily, right, an employee would not be eligible for FMLA leave unless he or she worked for the company for 12 months, right, and 1,250 hours. For purposes of FMLA under the Families First, disregard that because that doesn't apply, right? Under the Families First FMLA portion, if someone has worked for you for 30 calendar days prior to April 1st, 2020, or 30 days prior to the date the employee wishes to begin leave, that individual is eligible, regardless, right? If they didn't work, the 12-month, 1250 rule doesn't apply. So, someone applies on April 1st, they have been employed with you since February 28th, eligible, right? Someone applies today, they have been, so today is April 7th, they have been employed with you since March 1st, eligible, right? The 12-month, 1,250-hour rule does not apply. So who else is eligible? This includes employees who have been laid off, right, on March 1st or later, or even before March 1st, because a lot of employers are laying off people before March 1st, who had worked for the employer for not less than 30 days, not less than 30 of the last 60 calendar days prior to the layoff, and then you rehire them. So this example would be something like this. You lay somebody off, let's say March 15th, right? Then you bring that person back, let's say on June 1st. Just because that individual did not work for you on April 1st does not mean that he or she is not eligible for the FMLA if he or she meets all the qualifications. When you lay somebody off and you rehire that person, right, that individual now, not automatically, but that individual is eligible for the benefits under the FMLA, right? They don't have to have worked for you on April 1st. Covered employers, same as the emergency paid sick leave, less than 500 employees. Joint employer, that issue, of course, still applies. The focus is going to be on control. Next slide, please. Okay, what is the reason an individual can apply for and be eligible for the FMLEA leave? Again, the unable to work or telework requirement is still there, right? So the individual, the employee is unable to work or telework due to a need for leave to care for the employee's son or daughter under 18 years of age if, right, the kid's school or place of care has been closed due to COVID-19 related reasons, or the care provider is unavailable due to the shelter in place order. Now, just like with the paid sick leave, this can include individuals who are 18 or older, right? To the extent those individuals are incapable of self-care. And just like with the paid sick leave, there's a broad definition of son or daughter, includes biological, adopted, foster child, stepchild, legal wards, or anyone standing in local parentis. So the same rules and application that we talked about for emergency paid sick leave for reason number 5, because this is the exact same reason, apply here for FMLEA leave. Next slide, please. Okay, the amount of leave and pay. So an individual is entitled to 12 weeks of job-protected leave from April 1st, 2020 until December 31st, 2020, right? It's 12 weeks. So just as they would under normally, if they weren't applying for FMLA under the Families First, they get 12 weeks. Same thing here. Still get 12 weeks. Now, importantly, this does not expand the 12-week entitlement if an employee has already exhausted it. So let's go through an example. So mom gives birth and she takes 12 weeks of maternity leave. And she exhausts the 12 weeks, let's say on February 15th. Now mom is applying for leave to take care of the newborn because mom's a single parent and has no other, there's no one else who can care for the child, right? The daycare's closed, there's no parents, dad's not in the picture, right? So mom needs leave to care for the newborn. Under the law, you would not be required to provide mom with that leave. Should you? Yes. My recommendation is yes. Why? Because it's the right thing to do, right? Another example, an individual takes prior to April 1st, takes leave for a serious health condition, right? Cancer, needs the full 12 weeks, exhausts the full 12 weeks. Now that individual has been unfortunately, diagnosed and tested positive for COVID-19. Now the individual needs leave to care for his child, right? Because again, mom's not able to, and dad's the only one who can do it, right? And now is applying for leave. Legally, you don't have to provide dad with the leave because dad already exhausted the 12 weeks because he was out for the cancer. Should you provide it? Yes, right? I mean, again, why? Because it's the right thing to do. So I will leave it up to folks out there as to how you want to apply, implement that. Again, you're not required to. You are not required to. If an employee has exhausted the 12 weeks, the law says you do not have to give another 12 weeks. Should you? I'll leave that up to you in terms of how you want to decide that. My opinion, it's the right thing to do, and we should. But again, that is a company-by-company decision. First 10 days of the 12 weeks are unpaid. However, the Department of Labor made a change on Sunday. Again, this differs from the Emergency Paid Sick Leave Act. Remember, under the Emergency Paid Sick Leave, where I said that employers cannot require employees to use any available leave prior to them being eligible for or taking leave. Well, the FMLA portion is a little bit different. As of Sunday or Saturday, the Department of Labor has made clear that we can require employees to use any provided or accrued paid leave under our current policies concurrently with the FMLA portion. So if I have 4 weeks of vacation and I am applying for and eligible for FMLA leave, right, to care for my son or daughter, you as an employer can require me to use those 4 weeks concurrently with the FMLA. So I'd use the 4 weeks, right? Then I'd have an additional 8 weeks left. Now, important to remember here, while you are requiring me to use my 4 weeks of vacation, you have to pay me my full rate of pay. Ordinarily, for this reason, it's only 2/3 the greater of 2/3 the regular rate of pay or the applicable minimum wage. But if you are requiring me that I use my available paid leave for those 4 weeks, you have to pay me my full rate of pay for those 4 weeks. When the 4 weeks are up, and then I've got another 8 weeks, then it's 2/3 the regular rate of pay. So be very careful there that you are not only requiring someone to use existing leave, but that telling that person during the 4 weeks you're using your existing leave, you're only going to get paid at 2/3. You're going to get in trouble, you'll get sued, right? So be very careful there. Again, it's 2/3 the regular rate of pay, right? The greater of can you go back one slide? Can we go back to there we go. Okay. 2/3 regular rate of pay, right? That's what an individual is entitled to, the greater of. So remember, again, I talked about be careful if you're paying someone close to minimum wage, right? If you're paying someone close to minimum wage and it's 2/3 of that, it's going to put them below the minimum wage. You're more likely going to end up paying them that minimum wage amount, right? So be very careful. Capped at $200 per day. Now, unlike paid sick leave where it's $200 per day and then $2,000 in the aggregate, because remember, that's only 10 days. Here it's 12 weeks. So it's $200 per day, $10,000 in the aggregates, right? $200 times 10, because first 2 weeks are unpaid. That's how you get the $10,000. Then we talked about that last bullet point. If you require someone to use existing leave, you have to pay them that full amount during the period of time they're using that existing leave. Next slide, please. Reinstatement rights. So, job protected leave. Just like if someone ordinarily would be entitled to FMLA for non-COVID-19 related reason, it's job protected leave, right? So we have to reinstate that person to the same or equivalent position with respect to pay, benefits, and terms and conditions, right? Job protected leave. There's one exception to that, two, but the first one applies to everybody. Not job protected if that individual is laid off. There's a layoff that happens during the course of the 12 weeks. And that individual would have been laid off regardless if he or she was present at work. If that's the case, then there is no job protected status. That individual, you don't have to bring that person back to work. But again, be very careful here not to start singling out folks who are on leave and having them part of that reduction in force if the reason is, well, you want them gone because they applied for the FMLA. So it has to be a true layoff, right? If it's a true layoff and you would have and my position would have been eliminated regardless if I took FMLA leave, then that is a legitimate layoff. If you're only doing it to get rid of me, that is not a legitimate layoff. You're going to get in trouble for that. So what if there's a small employer exception? This applies for folks out there who have less than 25 employees. But it's not just one layer. There's multiple layers to this. So if you have fewer than 25 employees, the job protected status will not apply if the following three bases apply here. First, you eliminate that employee's position due to an economic or operating condition that affects employment due to a COVID-19 related reason, i.e., what does that mean? It means layoff because of the economic downturn, right? So you meet reason number one if you do this. If you eliminate my position due to the economic downturn that COVID-19 has caused, you meet it. But it doesn't stop there, right? Remember, if you have more than 25 employees, it stops there, right? And then no job protected status. If you have fewer than 25 employees, it doesn't just stop there. There's two other additional elements you have to meet here. The second one is that you have to make reasonable efforts to reinstate me to the same or equivalent position, which means you have to look around in your employment and say, is there another open position, right? So we eliminated Scott's position. Is there any other position that's open at the company that we can put him into? If the answer to that is yes, you have to put me in that position. If the answer to that question is no, then you go to bullet point 3 here. Over the next year, you have to make reasonable efforts to put me in any available position that becomes open. So over the next year, right, from the time of the layoff, if a position becomes open at your company that I qualify for, I get to go to that position. So you offer it to me. If I say no, you don't put me in it, but you have to offer it to me, right? So that is very important here because this is a multi-layered analysis. It's not as simple as you just saying, well, we've eliminated Scott's position. Not enough. You eliminate my position. You have to try to find an open position in the company for me. And then over the next year, if there isn't anything, to the extent something comes available, you have to offer that position to me. If I say no, end of discussion. If I say yes, you put me in that position. Again, this is only for employers who have less than 25 employees. Next slide, please. Employer prohibition, so it's no different than the emergency paid sick leave. We can't discriminate, we can't retaliate, we cannot require employees who take leave to find a replacement for their shifts. We could be sued by employees. Now, one caveat to this. Under the Fair Labor, under the FMLA, in order for employees to generally be subject to that, right, you have to have 50 or more and over 50 employees. So that applies here if an employee wants to sue you. So while you may be subject to it under the Emergency Family and Medical Leave Act expansion because the employee worked for 30 or more days, right? If you have 20 employees, that employee will not be able to sue you in terms of filing a lawsuit against you because you don't have 50 employees. But don't smile just yet. That doesn't mean the Department of Labor can't take action against you. So while an employee may not be able to sue you because you don't have you have fewer than 50 employees, that doesn't mean the Department of Labor won't go after you, and they will. So it's a very small victory. The employee, if successful, get back wages, liquidated damages, and attorney's fees, just like what we talked about in the emergency paid sick leave portion. Our notice requirements, again, that poster is out there. Make sure it is in your workplace and you provide it to employees working remotely and you provide it to any new employee through December 30th. Employee notice requirements, the employee is required to provide you with notice of their intent to take leave. They're supposed to give you as much notice as is practicable, right? What does that mean? You know, does the employee know today, right, that the school is closed? Yes. Does the employee know today, or did they know on April 1st? Yes. So arguably, you know, how are you going to enforce this? It's going to be difficult, right? You can say, give me advance notice of 6 days. All right, well, the employee has to give you advance notice of 6 days. Everybody knows the schools are closed, though. So, again, this may not come into play, but it is out there. The employee is required to give us as much notice as is practicable. Next slide, please. What information, right, must the employee provide for any leave under the Families First Act, right? We went through that under the emergency paid sick leave. At a minimum, right, all employees, name, qualifying reason, oral or written statement. This should be in writing because we want to know why they're unable to work. Why, you know, saying that they are unable to work. And the dates for which leave is requested. That's for all leaves. So both under the emergency paid sick leave and the FMLA leave. Next slide, please. As it relates to the FMLA leave, right, the Department of Labor has made clear, again, this is through the IRS as well. So, again, we talked about there was some confusion because the Department of Labor, if you read the specific regulation, just says that it does not specifically say that an employer can require this. But remember, you have to read the Department of Labor regs in conjunction with the IRS regs. And the IRS frequently asked questions. And in that particular provision for the Department of Labor, the regs, it does refer to the IRS regulation. So that's where our support is at Greensfelder. We're saying you can require this from the employee. So you can require, right, that the employee provide the name of the child being cared for, right, the name of the school or place of care that is closed. If there's grandma, that's grandma. A representation that no other suitable person will be caring for the child during the period of leave, right? That's important. And then again, what I alluded to earlier, the IRS has mandated this in their guidance. It said that with respect to an employee's inability to work or telework because they need to care for a child who's older than 14 during daylight hours, the employee must provide a statement of what specific circumstances exist that require the employee to provide care during that time period, right? So daylight hours, let's say 7 to 7. The kid's 15 years old. The employee is required to provide a statement on why that employee needs to be home to care for that 15-year-old or that 16-year-old or that 17-year-old or that 18-year-old, right? You need this. And it's required because the IRS says so. And if you want to apply for and get those tax credits, you need this information on there, right? So on here, I included the particular links to the support for what we're talking about here. Next slide, please. Okay, interplay between employee paid sick leave, the emergency FMLEA, and other forms of leave. So what happens if an employee is out and currently receiving workers' comp or temporary disability benefits, is that individual eligible for paid leave? And the answer is no, they're not eligible. So to the extent you have someone out on workers' comp, to the extent you have someone out on short-term disability, that individual is not eligible for paid sick leave or the expanded family and medical leave. Why? Because that individual is unable to work, right? You have to have work available. And there's no work available for that person because they're out on workers' comp leave. Now, if an individual is out on workers' comp leave and they are subsequently released to light duty, right, and you have light duty work available, to the extent then that individual meets any of the qualifying reasons, that individual would be eligible, right? So while they're out, not eligible. While they are, after any time they're released, if they're released to light duty, you have light duty available, you go through all the other analysis that we've talked about, an individual could be eligible. What about if an individual is out on a employer-approved leave of absence, right? So this scenario has come up already for me. An employee is out on FMLA leave. So let's say the employee started taking FMLA on March 15th, and you approved that FMLA leave of absence. Now, that FMLA leave of absence is unpaid, right? So while that employee is still out on that FMLA leave of absence for the serious health condition, that's unpaid, right? To the extent you require them to use your policy state that they have to use any paid leave concurrently. However, let's say the FMLA leave, the employee chooses to get paid, right? Because there's no paid leave, and they say, well, I want to terminate my FMLA leave because I have a child at home and I am a single mom and I need to take care of that child. So let's put aside my serious health condition for now. I'm going to voluntarily terminate my FMLA leave. If that employee voluntarily terminates the unpaid leave and then says, I want to apply for FMLA, the paid FMLA, under the Families First legislation, because I'm a single mom, no one can care for my child, and I need to be home for the child, the employee can do that, right? But they first have to terminate the unpaid FMLA and then start with the paid FMLA, right? So a scenario like that has happened for one of my clients. That's how we've handled it. We told the employee, you have to terminate your leave, right? And that's up to the discretion of the employee. If the leave of absence is mandatory, so an employee is out for disciplinary related reasons, right? And the mandatory FMLA leave, that person is not eligible for leave under the paid sick leave or FMLA because, again, there's no work available for that employee, right? You're at home because you're being punished. There's no work available for you to do at home while you are being punished. It is a mandatory leave that we impose. You, employee, are not eligible for leave. Next slide, please. Okay, so this has been a lot of questions that I'm getting as well. Status changes, right? So we change an employee's status, and are they eligible once we change their status for paid sick leave or the FMLA pay? So let's go through several of these examples. Let's say we reduce somebody's hours, and they're still working. So someone's working 40 hours a week, and now they're only working 30 hours a week, right? That individual is not eligible because that individual, as of now, is not prevented from working or teleworking, right? You just reduce the hours. So if the person says, hey, you reduced my hours, I want to apply for leave, and it looks like I qualify, but I'm able to work from home, right? Not eligible. The reason, of course, they're not unable, because you have to be unable to work or telework. And even with the reduced hours, even though the employee qualified for reasons 1 through 6, right, under the paid sick leave, that individual says, the reason I'm going out on leave does not prevent me from working from home. So, yeah, I can work from home. Not eligible. You have temporary laid off or furloughed everybody. So this includes your exempt and non-exempt folks. This is critical due to a lack of work, either before or after April 1st, 2020. Those individuals are not eligible for paid sick leave or FMLA leave. The reason is There's no work available. And the department has made clear that if there is no work available for the employee, right, no work available, that individual is not eligible for paid sick leave and or FMLA, right? So I want to stress that. Temporary layoff or furlough everybody. So in essence, you've shut down the whole plant, right? Nobody's doing any work. Not eligible due to a lack of work, right? So let's go through another example, and this has come up a couple of times from my clients. So you undertook a temporary layoff or furlough, but you've only temporarily laid off or furloughed your non-exempt workers, right? The press machine operators, because they can't take the press machine at home. You can't take the press machine home with them. But your exempt workers are still working, right? Your office workers. They're still able to do their job from home. In that situation, your non-exempt workers, the press machine operators, they would not be eligible for leave. Again, the reason being there's no work for them to do. Your exempt employees, they may be eligible, right, because there's work for them to do. They're performing it at home, right? Now, if they meet one of the eligibility requirements, that employee would then have to say, I am now unable to perform the work due to a COVID-19 related reason. So there may be scenarios where your non-exempt employees who you furloughed are not eligible due to a lack of work, but your exempt employees who are working from home, they may be eligible because they're performing work. Again, the caveat being they now have to assert that I'm unable to work. Terminated. If you terminated anyone, they're not available. Hands down, no question there. There's nothing gray about that. You terminated, you're no longer an employee. What about this? And I had this happen with a client. So the client decided to shut down at the end of day on April 3rd, 2020. But before then, on April 1st, several employees applied and were eligible for paid sick leave under both the FMLA and the paid sick leave portion. In that scenario, the individuals would be eligible for 3 days of pay, right? I have 4-1 and 4-2, but also 4-3 on here. So they applied or were eligible on April 1st, applied or are eligible on April 2nd, and are eligible on April 3rd. The plant shuts down completely on April 3rd, end of day. As of April 6th, they're no longer entitled to benefits, right? So they're only entitled to benefits, right, for April 1st, 2nd, 3rd through the end of the day. Because you shut down completely at the end of the day on April 3rd, no one is eligible for benefits, but those several employees, right, can collect for those 3 days before you shut down at the end of the day on April 3rd, 2020. So keep that in mind. It may be a scenario where you have to pay 3 days worth of benefits, right, because you chose to shut down, depending on what day you chose to shut down completely. Next slide, please. Non-enforcement period. So the Department of Labor will give you employers a mulligan. The mulligan started on March 18th, which is of no use to anybody because the department's, the Families First legislation was not even enacted yet. So you have a mulligan if the mulligan starts from April 1st through April 17th, 2020. However, it is not a complete mulligan. Only if you acted reasonably and in good faith to comply with the act. So for example, I can see this again with the regular rate of pay. If you are miscalculating the regular rate of pay, and for example, someone who got commissions, you didn't include commissions in there, you only included the base pay, right? Well, you can argue successfully, Department of Labor, I reasonably attempted and in good faith to comply with the act. I just was unaware that I had to include commissions. Okay, that's something where you reasonably and in good faith tried to comply. If someone applies for leave and is eligible and you say, no, I'm not giving it to you, doesn't matter, too bad. That is not you acting reasonably and in good faith, right? The Department of Labor will then, if that happens today, they could sue you beginning today. So during the April 1st through 17th period, the department will focus on compliance assistance. You also must make written affirmations to the Department of Labor, right? So using that regular rate of pay example, you must, in writing, tell the Department of Labor and make a commitment that all affected employees will be paid as soon as practicable. What does that mean? Does that mean 5 months from now? No. Does that mean 2 months from now? No. It means as soon as practical, meaning within a couple of weeks, right? So it's not 3 weeks, it's not a month, it's not 2 months, it's as soon as practicable, i.e. the Department of Labor will probably even require next payroll period. So you have to make that written affirmation, and then also you have to assert that you make a written commitment to comply with the act in the future. In essence, saying, you know, I didn't comply now, but in the future I know what I need to do, and I will comply. So again, be very careful because you have to be acting reasonably and in good faith, and this only applies through April 17th. Next slide, please. So this may be a good position to stop to, Cindy, in terms of if anybody, before we get into the tax credits, does anybody have any questions related to the family and medical leave portion?
Yeah, there's a couple questions that we have. One you just briefly touched on, Scott, and it was regarding rate of pay. Can you go over again how commissions are handled? And there was another question about if someone has routine overtime, how those two different scenarios need to be addressed when it comes to calculation of pay.
Sure. So for commissions, that is included in someone's regular rate of pay. So the question is, how do we determine, right, what someone's average regular rate of pay is if they always are, you know, if they're get an hourly rate plus commission? So my advice has been that look at the last quarter, right? So whatever the last quarter is, right? So it's beginning from January 1st, you go on average there. So take January, February, March, right? That's a 3-month period. Again, to the extent someone applied on April 1st, you do an analysis there to determine what is that individual's average hourly rate of pay when you include all the commission that that individual earned, right? In that scenario, you would say, so if when you take my hourly rate of pay plus all the commission that I earned over that 3-month period, if it comes to $15 an hour, well, it's $15 an hour then. So that's why I've been advising my clients, go back at least through January 1st, make the analysis there, because that's a 3-month period, and that's, I think, a good average to determine what someone's regular rate of pay is when you include the commissions in that. For the hourly, for overtime hours, so while that must be included, remember, as it relates to the emergency paid sick leave, they're only entitled, and FMLA, to 40 hours a week, right, 80 hours total. So going back to the emergency paid sick leave, let's say that over the past 5 months, pardon me, I worked 30 hours, and then every single day I worked 15 hours, you know, every week I worked 15 hours of overtime. So you use the last quarter. That I worked 45 hours a week, so that 45 plus times 2 is 90. You're not required to provide 90 hours, right? But you are required to provide up to 80 hours. And the argument there the employer would make is, well, going back the last 3 months, right, I averaged at least 80 hours, right? If not 80, but the 90. So in that situation, you're not given the 90, right? Your capping is still at 80 because that's the most anybody could ever receive under the emergency paid sick leave is 80 hours. So it doesn't matter with overtime hours that the total came to 90 because it's capped at 80, right? As it relates to FMLA, same. It's capped only at 40 hours. So it doesn't matter if I work 50 hours a week, you're still paying me for a 40-hour work week. If, again, when you look at the average number of hours I worked, you know, with overtime over, let's say, the last 3 months, 45 hours a week, right? You're still paying me only for 40 hours, right? So overtime hours does not get included such that you're paying someone more than 40 per week, right? Emergency paid sick leave, 40 hours, times 2, 80, capped at 80. FMLA, 40 hours per week over the course of the 12 months. It is not 45 hours per week over the 12 months because someone worked overtime, right? You're capping it always. It is based on a 40-hour work week. I just said to include overtime there because to the extent someone only worked 25 hours, but for the past, you know, normally, but the past 3 months worked those additional hours to get them over 40, that's what you're basing it off of. You can't say, well, 3 months ago, you were only at 25, so that's what we're going to give you. That's what I meant by you have to include overtime hours. It's, what were they working over the past, quarter, let's say.
Okay. One more question, and this came in from a couple different people. For employees that are on emergency pay sick leave, how is a holiday handled? Some companies may have half a day this coming Friday, may have a full day because it's Good Friday. How should holidays be handled? Are they full pay or are they at a reduced rate?
Let me confirm that because I haven't had that question yet. That being said, I can tell you what I think, but I would need to confirm that. And I think the answer there is if it's a holiday, right, and you're only open for 8 to 12, then if the employee was working for you, he or she would only get hours for 8 to 12, right? You wouldn't pay the full 8-hour day because that employee wouldn't be working that full 8-hour day. But let me confirm that because I have not had that question come up yet. So whoever asked that question, feel free to email me on the side, or I can certainly answer that and give it to the IMA, and they will post that answer.
Yeah, we can include that on our Q&A. And then one more question before we get back to the presentation. For employees requesting leave under condition number 5, about the childcare and the schools being closed, if they have one child who's 14 or older, but then has others who are younger than 14, can they still be eligible for leave even though there's somebody who's 14 years old or older in the household?
You can, but again, you have to provide a statement saying what special circumstances there are that you need to be, let's say the kid's 16, that you need to watch the kid who's 16, right? So in that situation, if you've got someone who is, an employer, someone who's 16 and 12, right, really at the end of the day, it's the 12-year-old that's going to matter. So you're going to be eligible for the 12-year-old. So you're not going to get, you're not going to, well, depending on how you apply that as employers, but, if my client came to me with that question, that employee would be eligible for the 12-year-old, right? So they'd get it for the 12-year-old, notwithstanding that 16-year-old. So they'd meet it for the 12-year-old. Whether or not they meet it for the 16-year-old, the employee may not say, hey, I don't even have to worry about the 16-year-old. I'm worried about the 12-year-old. So in that scenario, if the employee met all the other requirements, remember the unable to work, for the 12-year-old, yes, the 16-year-old, they may not even factor in it because there's 2 kids. It's only when the kids, both kids are over 14, then that's going to be a different analysis, right? Where the employee has to give a reason on why the kids who are 16 and 17, you need to be home with them, right, between the hours of 7 and 7, because presumably they're able to watch themselves. So that's what so in that scenario, again, it's going to differ.
Yeah, so nobody's making the assumption that the child who's 14, 15, 16 should be taking care of the kids that are younger than that.
Well, it is a suitable, now could the employer make that argument? Yes, but the Department of Labor, how they've defined it is a co-parent or another guardian, right? And so
Gotcha.
Under that example, right, I mean, could you? Yes, because the Department of Labor hasn't addressed that. But in that scenario, based on what the Department of Labor is saying, that, co-parent is a suitable person, right, is a co-parent or another guardian. Now, could a suitable person be an 18-year-old? Yes, right? If that 18-year-old has watched a kid in the past, watched a 10-year-old sibling in the past, yes. So certainly there's a scenario there. The Department of Labor has not fleshed that out. And I guess I haven't had that situation come up yet, but my advice would be, depending on how old, not only does it depend on how old the kid is, but the question should be, has your 16-year-old ever watched a 10-year-old before for an extended period of time? And if mom or dad says yes, then arguably you could reject their leave request because that 16-year-old is a suitable person. Has a driver's license, has a car, potentially they'd be able to watch that child. So, that again, that's a case-by-case scenario on how you want to handle that.
Okay. All right. We can get back to the presentation.
Okay. All right. So tax credits. So we as employers can get tax credits dollar for dollar for all money being paid out for paid sick leave and being paid for the family and medical leave. Now, I had a question the other day from a client who said that we started giving paid leave prior to April 1st. Do we get tax credit for that leave that we were paying prior to April 1st? And the answer is no. You are being generous, but unfortunately that generosity the Department of Labor does not recognize, or the IRS does not recognize. So if you are giving paid leave prior to April 1st, that leave does not constitute leave for which you can claim tax credit. It's only for the amounts being paid beginning April 1st through December 31st, 2020. You receive an immediate tax credit, right, for amounts paid. Now, you're going to report that on Form 941, right? You report any qualified leave wages and related credits on federal unemployment tax returns. That's a 941 form. But employers can also immediately withhold qualified leave wages, right? And this relates to any applicable qualified health care plan expenses as well from the employer's share of Medicare tax, from employment taxes, right, including taxes that we would need to be deposited with the IRS. So it's pretty broad in terms of your taxes, right? Healthcare plan expenses, so security taxes as well, that's all included. You can also seek a prompt refund of any excess payments. So let's go through an example here. Next slide, please. So let's say you paid out $5,000 in sick leave, right? And you're required to deposit at the end of the quarter $8,000 in payroll taxes. This includes taxes withheld from all your employees. So it's not just the employees who are out on leave. In that scenario, when it came time to pay those payroll taxes, you would only have to deposit $3,000 because it is a dollar for dollar credit, right? And dollar for dollar, you offset that 5 from the 8, it's only 3. You only have to deposit $3,000. What about a scenario where you paid $10,000 in sick leave and you're required to deposit $8,000 in taxes? In that scenario, come time for the deposit, you would not have to make any deposit whatsoever because you've already exceeded that $8,000 in the $10,000 in sick leave pay that you already paid out. And not only that, you'd be able to file and request an accelerated credit for the remaining $2,000 for the next time you have to pay taxes. So that's how that's played out. Very simple examples, of course, but that's how it's going to be played out in reality. Next slide, please. Okay, record keeping requirements. Very important. I've gotten this question a lot. Are employers required to keep records? Yes, yes, you are. All documentation provided by the employee requesting emergency paid sick leave or the emergency FMLA leave, regardless if the leave was granted or denied, right? This includes any documentation of verbal statements from the employees regarding leave. So, as I stated, we have created an application form for our clients to provide to their employees. That application form would be included as part of these records. So we'd have to, for each employee who applies for leave, regardless if that employer granted it or denied it, they'd have to keep that form, right? They'd also have to include any other documentation, be it the shelter-in-place order, be it an the employee's doctor's note from a healthcare provider, right? All that documentation you must keep for a period of 4 years, regardless of whether you granted or denied the employee's request. For the small business exemption, whoever the authorized officer is who's making those determinations, that documentation also has to be maintained whether or not you grant or deny the employee's request. Remember, that's for reason number 5 the employee is looking to take leave to care for their child. That's for reason number 5. So you have to keep those records as well, regardless if you grant or deny the leave. Next slide, please. So this is a slide more as an FYI. We don't have to go through all of these since the slides will be made available. But if you want to claim the tax credits, the IRS has said that you have to provide this, you have to keep and maintain, and in most circumstances provide the following documentation. So now leave that up there for a couple seconds for folks to review. We don't need to go through all of those. Again, this is more informational purposes. These slides will be available, but this is what you will need. And if you look at bullet point number 5, that any other documents needed to support its request for tax credits, pursuing the IRS applicable forms, that's the support that I was talking to earlier. This is from the IRS. That's the language that I'm relying on that I believe, right, that allows us as employers to require medical documentation, right? So when the employee goes out on leave, we can require that the note from the doctor. This particular bullet point here, this particular language from the IRS is what we're using to tell our clients, yes, you can request that doctor's note. Any other documents needed to support its request for tax credits. The IRS has not defined that, right? That being said, right, our belief is that any other documents does include medical documentation. Next slide, please. Okay, wage and hour consideration. So we've been getting these questions a lot as well. Do we have to pay our employees who are at home and there's no work for them to do? The question is, well, it depends. It depends on their classification. So we'll go through the non-exempt workers first. Non-exempt are your hourly workers, right? Non-exempt means they're eligible for overtime if they work over 40 hours in a single work week. Non-exempt workers only get paid for the time they actually work, right? So if a non-exempt worker works 15 minutes the entire week, they get paid for 15 minutes. If they work for 30 minutes the entire week, they get paid for 30 minutes the entire week. So for your non-exempt workers, there is no requirement, there is no law that requires you as an employer to pay your non-exempt employees who are at home and not doing any work. I'll repeat that. There is no law that requires you as an employer to pay for your non-exempt employees who are at home and not doing any work. Now, what if they're at home and doing work? Well, then that's different, of course. You have to pay them for all hours, for all time that they're actually working. Remember, the minimum wage and overtime requirements are still in place here, right? If someone works over 40 hours, right, even though they're working from home, we have to pay time and a half. Now, this next bullet point, I want folks to pay specific attention to because I've had this come up already. Let's say that normally the non-exempt employee is working, the hours are 9 to 6, right? And that you give 1 hour of unpaid break time for a lunch period. That still applies here, right? And so even though the employee's working from home, they still need to take that hour lunch, because if they do not, right, and they submit a time record to you and don't tell you that they didn't clock in and out for that hour lunch, and you assume that they did, but they didn't, and they worked during that hour lunch period, well, now that's 5 hours extra each day for the week. And you would have to pay time and a half on those 5 hours, right? So we need to make sure we're telling our employees who are working from home, make sure you're clocking out, in and out for lunch period, right? And if not, let us know about that, because we need to know, because that affects how much we're paying you. Again, in that scenario where someone ordinarily works 9 to 6 and they take the unpaid hour for lunch, if they don't tell you that they didn't take that unpaid hour, or they didn't tell you they didn't clock in or out, or they didn't tell you that, hey, I worked during those hours, you would have 5 extra hours of work each week. You would have to pay 5 hours of extra overtime. So it's very important to remind our employees when they're at home, right, assume you're at work. If you didn't take your lunch, let us know. If you forgot to clock in and out, let us know, right? Those requirements are not lapsed because the employee is working from home. To that point, we still have to track hours, right? Hopefully you have a mechanism or platform in place where employees can track their hours. Just because they're working from home does not mean that the Department of Labor's requirement that employers record time worked each day and each work week, right, goes out the door. It is not. And remember, as of February 19, 2019, this means exempt employees. So all of your exempt employees, we have to be tracking hours. All of your non-exempt employees, we always had to track their hours. So if you've got non-exempt employees who are at home and not tracking their hours, make sure to remedy that as soon as possible, right? Because they need to also be tracking their hours. And quite frankly, they had to be doing that as of February 19th, 2019. Remember that just because folks are at home does not mean that we can't have some structure in place, right? You can require, if you want your workers working 9 to 5 because that's what they work when they're in the office or they're in the plant, then you tell them you're supposed to be required to be working 9 to 5. If there's deadlines that need to be met, those deadlines don't go out the door because someone's working at home. You still enforce those deadlines. And if they don't, you write them up, right? So again, assume that folks it's business as usual if you have people working from home. If you want them working 9 to 5, you tell them you're working 9 to 5. Next slide, please. Exempt employees. So exempt employees are a little trickier, right? Because remember, with exempt employees, they're entitled to their full salary so long as they perform even what's called a de minimis amount of substantive work. What does that mean? That means if I do 1 hour of work a week as an exempt employee, you, employer, have to pay me my entire week's salary. And so there's been a lot of question here. Well, we don't have enough work, right, Scott? We don't have enough work for the next month. We don't want to keep paying this exempt employee his or her full week of salary if they're only doing, 8 hours of work a week, right? How do we get around that? What can we do? And we'll talk about that. So this does not include though, right? So to the extent that an employee tells you, well, all week I check my email every day for 1 hour. I didn't respond to any emails. I just checked my email for an hour, pay me. The answer is no, we're not going to pay you. And we have justification for that. Courts have said that if an employee is just checking their work email and not responding, right, just literally checking their email, that is not considered work that requires payment, right? So to the extent someone's checking their email, but also responding to emails, well, that's not work, so that's different. Next slide, please. So let's go through 3 different scenarios. The next slides will talk about how do we handle the exempt employee who we don't have enough work for and we don't want to keep paying their full week salary. So the first thing we can do is we can reduce the exempt employees, reduce their salary, right? Now, there's certain things we have to keep in mind before we reduce their salary. So one thing I want to talk about too, because some clients have been asking me this. Well, what if we just reduce the hours? Doesn't matter, right? Remember, exempt employees don't associate exempt employees with hours. Because if you reduce my hours from 40 to 30, and I work those 30 hours, you still have to pay me my full week salary, right? It makes absolutely no difference that you, in fact, reduce my hours. And in fact, it's a benefit to the employee. So the employee says, great, I work less hours and you're still paying my full week salary. So what you need to do there is if you, to the extent you have exempt employees who are working a 9 to 5 gig, not only you reduce their hours, but you reduce their salary, right? So if you want your exempt employees only working a 4-day work week, figure out how much 4 days of salary is, and then reduce the employee's salary to 4 days a week, right? So now, with that though, the reduction must be prospective, and it's got to be in writing. What I mean by prospective is you can't tell me today, Scott, as of today, we're going to reduce your salary because we're in a current payroll period. It has to be for the next payroll period, right? So whenever that next payroll period starts, that's when it goes into effect. Has to be for a bona fide reason. An economic downturn qualifies. So you've met the 2 requirements. The third one's the most important. is that the reduction in salary cannot reduce the employee below the exempt threshold of $684 per week. I just didn't come up with that number out of the blue. Where did I come up with that number? On January 1st, 2020, the Department of Labor increased the exempt salary threshold to $684. It was at $455, is now $684. The equivalent to that is $35,564 a week. So if you reduced an exempt employee's salary and they're not making at least $684 a week, that employee automatically becomes non-exempt. So make sure if you reduce the salary and if you don't want them to be non-exempt, that they're not reduced past the $684. And of course, the duties have to remain the same, right? They still have to meet part 2 of the test, which is the duties test. Next slide, please. So what if you in fact reduce the exempt employee's days of work? So this scenario will come up in this particular situation. Let's say you are open only on Monday and Tuesday, and then you are closed Wednesday, Thursday, Friday. Okay, so that's the scenario. Now, your exempt employees, when they perform any amount of work on Monday, right, you still have to pay them for the entire work week. So where's the cost savings here? The cost savings is this. On Wednesday, Thursday, and Friday, you can require that exempt employee that while we're closed, you have to use and exhaust any paid leave you have available to you, right? So an employee has, let's say, 7 days of vacation. So for week 1, they work Monday and Tuesday, Wednesday, Thursday, Friday. You can require that they use 3 days of their vacation. This, of course, is beneficial to you because it exhausts any accrued leave that the employee has. The employee's not going to be happy, but it doesn't matter, right? So the employee can say, hold on a second, you're telling me that while we're off and the place of business is not open, that you are requiring me to exhaust my paid leave. And the answer is yes, that's exactly what I'm telling you. And we can do that. Of course, this doesn't apply if the employee does not have any paid leave available, right? So we're still paying the full salary, right? We're just, now the benefit to us is we're getting the employee to exhaust any paid leave they have. Next slide, please. So this is the scenario where I'm advising most of my clients in terms of the exempt employee who there's not enough work. You just temporarily reclassify them to non-exempt status, and you can do that, right? So you can reclassify as non-exempt, you start paying them an hourly wage, and then if there's only 15 hours of work available in the week, you only pay 15 hours of work. If there's 20 hours of work, you only pay 20 hours of work. You don't have to pay my full salary, right? So let's say each week I'm entitled to ordinarily $1,000 a week. You reclassify me as exempt. If I only do 10 hours of work a week, I don't get that $1,000. I only get whatever my converted hourly wage is to multiply that by 10. That is all I'm entitled to. You can do that under the law. So this is the advice I'm giving most of my clients when they tell me there's not enough work to do. Just reclassify them, right? Now, be careful if there is enough work for that employee to do, and that employee works over 40 hours, now you have to pay overtime, right? So this, I would say, I only recommend when we know for sure there's not going to be 40 hours of work. There's going to be, let's say, 35 or less, or even 30 or less, right? Reclassify to non-exempt, only pay the hourly wage, and only pay for the amount of time actually worked. Next slide, please. Okay, employment expenses. Why am I talking about employment expenses in a webinar related to COVID-19? This is why. Under the Illinois reimbursement law, as of January 1st, 2019, right, we as employers have been required to reimburse employees for any necessary and reasonable business expenses that they incur. Our employees who are at home working are incurring necessary and reasonable business expenses for which they need to be reimbursed, right? Cell phone. If an employee doesn't have a landline, and most folks don't, and they're using their cell phone to make business-related expenses, well, guess what? We have to reimburse them for that cell phone. If they're using the internet to log on to our platform, our system, because they need to check their work emails, guess what? You have to pay them for the internet. If the employee needs a printer at home because they have to print materials out, guess what? To reimburse them for the printer. How do we get around this? We don't necessarily get around it. We just mitigate our exposure. We mitigate our exposure by preparing an expense reimbursement policy for this time period, right? So I've done that for my clients, so they're not paying the $80 cell phone bill. They're not paying the $200 internet bill. They're not paying the $200 printer bill, right? So we draft a reimbursement policy, and in that policy, we state we are only going to pay up to this amount. So I've done a combined amount for internet and cell phone of $20, right? We can do that. In terms of a printer for any other equipment that an employee uses, we say we will pay up to a certain amount, but you have to tell us first what you're going to purchase, right? And then from that, we will determine how much we're going to pay, right? So I had an example where a client did not have a reimbursement policy, required the employee to work from home. The employee did not have a computer or a laptop, went out to Best Buy, purchased a $1,500 laptop. After purchased it, rightfully so, sent us the bill and said, pay me $1,500. We did not have a reimbursement policy in place. So of course, I quickly put together a reimbursement policy. We said that was in effect as of April 1st, and we only paid $500 of that $1,500. So that example can happen. If you have an employee who's got a laptop and they buy a laptop and you don't have a reimbursement policy in place, right, and the employee needs that laptop, well, guess what? You're going to have to pay for that laptop. So make sure you have expense reimbursement policies in place addressing the particular expenses that your employees may incur while they're working from home. Next slide, please. Unemployment benefits. So the other big ticket item here. So the IDES has created a Q&A for employers and employees that answers questions related to unemployment benefits. I have the link on here. I know you can't access that link, but if you Google IDES FAQ COVID-19, that will take you to this particular link, and you'll get that frequently, the questions, the FAQ. Employer contribution rates. So as of today, unless IMA, you tell me differently, I know as of Friday, this wasn't the case, but as of today, our contribution rates as employers will continue to increase for each claim that the IDS pays out. I know that there's a big push to stop that, but as of today, I don't believe that has been enacted yet. So hopefully it does, right? Because if not, we certainly want our employees to collect unemployment if they're eligible. But we don't want our employer contribution rate increasing each time that the IDS starts paying out on those claims. So I know that there's a big push for that. As of today, I'm not aware that that push has actually become memorialized into, in fact, legislation such that the employer's contribution rate will not be increased for each claim that's being paid out. So that's a TBD. 7-day waiting period is waived. So what this means is that ordinarily an employee, if they file for unemployment, right, they'd have to wait 7 days. So if I applied today, I would not be eligible to collect benefits until a week from today. That has now been waived. If I apply to today, I can start collecting benefits today. Now checks aren't being issued for at least, I believe, 2 weeks. This is important as well. Most employers don't know about this. And this just isn't in this pandemic period. It's always been the case. When we lay off or terminate employees or they're separated for any reason, we are required to provide those employees a 4-page booklet from the IDES. That has always been the case. Most employers don't know about that. If you Google IDES, required booklet termination, you'll get that link. It's a 4-page booklet. Print it out. To the extent you've laid off or terminated people, email it to them. So that's always been the requirement, just most employers don't know about it. Next slide, please. Okay, so different scenarios, I've gotten questions in terms of when will my employees be eligible for unemployment benefits. Let me just take 1 minute here to address this. When that question does come up, and it will, my advice to you and my advice to my clients is you answer it this way. So when the employee asks, what should I do? Should I apply for unemployment? Your response is this. You need to do what you believe to be in your best interests. That is your default response. Why do I say that? Because there is a retaliation component to the Illinois Unemployment Insurance Act. It says that if an employee retaliates against an employee for engaging in protected conduct, saying, I'm going to, or I haven't filed for unemployment, right, I'm going to once you terminate me, you could be subject to a lawsuit. And we don't want a scenario where you tell employees, listen, we're going to lay you off, right? You're probably eligible for unemployment. And the employee comes to you while they're still an employee and says, should I apply for unemployment? And something you say in response to that leads the employee to believe that you are dissuading the employee from applying for unemployment, right? Or you're retaliating against the employee in some way because they told you they want to apply for unemployment. Now you're subject to a lawsuit. So in that scenario, you respond, you employee do whatever you believe to be in your best interest. There is no argument there. There is no gray area, right? No one can say that with that response, you dissuaded employee one way or another to apply or not apply, right? The response is you do what you believe to be in your best interest. That's how I'm advising all of my clients. That's my advice to you for that reason, because we certainly don't want an employee to come say, well, you dissuaded me, I'm now going to file a lawsuit against you, right? The last thing you want. Okay, with that being said, when are employees eligible? If they are receiving paid sick leave or FMLA pay, not eligible. If they are receiving paid sick leave under a company policy, not eligible. Very important here, right? So if you're requiring someone while they're out to use accrued vacation, vacation is disqualifying income under the Unemployment Insurance Act. So if that employee tries to apply for unemployment during the time period that they are using vacation and being paid out of vacation, you protest that, and that individual would not be eligible for benefits. When they're done, when they've exhausted their vacation time, right? So let's say it's 1 week, well, then they can apply and collect. But for that 1 week, vacation pay is disqualifying income. If you have temporary laid off or furloughed somebody because of a temporary closure, right? So Governor Pritzker's shelter-in-place order, are employees eligible? The answer is they're eligible, but so long as they're prepared to return to work as soon as you reopen or the shelter-in-place order ceases. So if when they're being interviewed by the IDS and the IDS says, are you going to come back to work on June 1st when the shelter-in-place order opens up? And I'm not saying that's when it will, I'm just saying hypothetically. And the employee says, yes, I'm going to, I intend to, eligible. If the employee responds, no, I have no intention of ever coming back, not eligible. So they have to be prepared to return to work as soon as you reopen. I've gotten this question a lot. The employee refuses to come to work for fear of contracting COVID-19, right? So they're telling you, I'm not coming to work because I think that if I, for whatever reason, right? And the answer is, are they eligible for unemployment benefits in that scenario? And the answer is, it depends. And I say it depends because this. If the employee has a good faith basis for not wanting to come to work and believing that they will contract COVID-19, and that basis is attributable to you, employer, and the employee tried to get you to resolve it, but you did not, they're eligible. So a scenario is this. Your employee calls you and says, I'm not coming into work because I have not seen a cleaning crew there. It is a cesspool of germs. In my cube alone, Scott and Cindy are sneezing and coughing, and you're not cleaning it up. So I told you about this last week. You didn't do anything about it, so I'm not coming into work. Yes, that employee would be eligible for benefits because the reason is attributable to you since you didn't clean up the work area, disinfect the work area. Now, scenario number two, the employee says, I'm not coming to work because, quite frankly, I just don't want to step foot outside of my house. I think if I step foot outside of my house, I will contract it just by breathing air. Has nothing to do with the workplace. Has nothing to do with you, employer. That individual would not be eligible for benefits. Okay, if an individual is confined to home because the doctor imposed self-quarantine to care for a family member, or because of Governor Pritzker's shelter-in-place order, is that person eligible for unemployment benefits? The answer is, it depends. Well, what does it depend on? The IDS has said it depends on whether the employee is able and available to work from home, right? And again, so that able and available, remember, that's different from the paid sick leave portion that's unable to, right? And that's why for the first bullet point, someone who is on sick leave under the emergency paid sick leave or FMLA, that's why they're not eligible for benefits. Because when you apply for unemployment, you have to say, I'm able and available. And when you apply for benefits under the paid sick leave, you have to say, I'm unable, right? So that's why those folks are ineligible. But let's talk through a couple examples here. Confined to home. If an individual is at the hospital and bedridden and unable to work, they're not able and available. So unfortunately, that person not eligible. If a person is self-quarantined and able to work, right? So they're not eligible for paid sick leave, right? Because they're not unable. But they'd be eligible for unemployment because they are able and available to work. So it's that scenario, right? Again, it's not a scenario that we would undertake. This is a scenario the department would undertake. I'm just going through here because to the extent your employers do ask you for questions, you know, this is what your response be if you're not taking my default answer. School closure, again, depends. Is mom or dad able to work while they're caring for the kid? If they say they are able to work, yes, get it. If they say they are unable to work, right, because it's a newborn, no, they're not going to get it. Reduction in hours, depends. I get this question a lot too. So what if we reduce someone's salary or wage, we reduce hours from 40 to 20? Will that person get unemployment benefits? The answer is it depends. And what does it depend on? Depends on if your salary, as the reduced salary, is that equal to or less than the individual, how much they'd collect for unemployment. So let me put this in perspective. High earners, right? Let's say someone's making over $100,000 if you consider a high earner. The most that individual could collect if they don't have a dependent or a wife, right, or a spouse, is $484 per week, right? So if you reduce that person's salary, or from 100,000 to 70, well, they're still making more of that weekly benefit amount, right? But that's the analysis. The analysis is, will that person with the reduction, will they be making equal to or less than what they could collect for unemployment? If the answer is yes, they're eligible. If the answer is no, they're going to make more, they're not eligible. Next slide, please.
And Scott, if you don't mind, we're just taking a time check right now. We are at 11:30. We still have 200 participants on the call, so I think we can continue with the presentation, but do you have a time estimate in terms of when we can get to the questions?
Yeah, we can take questions now, or I probably got another 15 minutes of actual presentation time. So it's up to you how you want to handle it.
Yeah, why don't we cover the unemployment, the federal pandemic unemployment benefits, and then let's take some questions. But yeah, we are still at 200 people still on the call.
Okay, so federal pandemic unemployment benefits. This is for folks who are true independent contractors. This is for folks who are self-employed and gig workers. And what I say by that is they are not eligible for, ordinarily, they are not eligible for benefits in a non-pandemic situation if a true independent contractor applied for benefits, if a true gig worker applied for benefits, if a true person who's self-employed applied for unemployment benefits. In a non-pandemic situation, they're ineligible for unemployment benefits in Illinois. So to help those workers, Congress passed what's called the Federal Pandemic Unemployment Benefits and Insurance Act. They're two separate provisions. So this is intended to cover two things. One, individuals who are not normally entitled to benefits, right? Now they are entitled to benefits. And it's also intended to provide those folks who are eligible, normally eligible, and who are getting benefits, a additional $600 payment on top of what the state is giving them. So let's go through an example. Let's say I am eligible for benefits. I'm not an independent contractor or gig worker, and I'm eligible for benefits. And I'm a high earner, and I get $484 per week. I will get each week through July 31st, 2020. Very important. This $600, that expires July 31st, 2020. After that, no one else is getting $600 additional on top of state benefits. So if I get $484 from the state, I'm also going to get from the state through the federal money. So I'm also going to get the $484 plus the $600 each week through July 31st, to the extent I still qualify. Also, it's been expanded to give 39 weeks of coverage. So ordinarily, right here in Illinois, you get 26 weeks, right? That has now been expanded to additional 13 weeks. So someone is going to be eligible for up to 39 weeks of unemployment benefits, right? Not your normal 26, that for a non-pandemic situation, you can collect up to 13 weeks of benefits. Next slide, please. So these next two slides we've got to go through quickly because you'll get the PowerPoint slide. These are the reasons if an individual, right, who is able and available to work but is unemployed, who is partially unemployed, which means reduced hours, or you're unable or unavailable to work, this is when you could collect that additional $600, right? This is also when you can collect as an independent contractor or a gig worker, right, the qualifications. So if you meet any of these requirements on this slide, and then if we can go to the next slide, any of these requirements, you'd be eligible for the benefits that I just talked about. And again, we don't necessarily need to go through those. This is just an FYI, and I know folks will be getting the slides at the end. So, Cindy, we can start taking questions now.
I think, Scott, it would be worthwhile if you go over the changes to the WARN Act, because I think that would be important to our members, and then let's start taking questions.
Okay, so I will tell you for the WARN Act too, after that there's only about 2 slides. So we may just want to go through everything and then take questions and just kind of finish it so we can take questions then, but I'll leave that up to you. Okay, Illinois Mini WARN Act. So this applies to the extent we have folks out there and you have either completely shut down your plants, or, and we'll go through the definitions, or you have undertaken a mass layoff. This will apply to you if and only if you have 75 or more employees. You have 75 or less. If you have less than 75, doesn't apply to you, okay? And this relates to notice in terms of you have to provide notice to your employees and to certain governmental officials. So mass layoff or plant closing, we'll define those. You have 75 or more employees, and that mass layoff or that plant closing will last longer than 6 months. If you know or don't know right now that, so let's say you know it lasts, at the time you make the decision to lay off, you know it's going to last longer than 6 months, you've got 75 or more employees, and then you meet either of these 2 requirements, which we'll go over. You have to provide notice, written notice to your employees of the mass layoff or the plant closure. If you undertake a plant closing or a mass layoff, and you don't know as of the time you do it whether or not it will last longer than 6 months, then you do not have to provide notice yet. I say yet in quotes, because if at any point later on you know that the layoff or the plant closing will last longer than 6 months, at that point you do have to provide the required written notice to the employees and the appropriate governmental officials. So, what is a mass layoff? A mass layoff means a reduction in force that is longer than 6 months. Again, that is very important because I've had clients who reach out to me and they say, well, no, it's only going to last 4 months. Well, then there's no WARN Act requirement here. So it is longer than 6 months, and one of these 2, at least 33% and at least 25 of your employees at least 25 employees, excluding part-time, same thing for that 33%, excluding part-time, have been affected. So if you have laid off at least 25 employees, and those 25 employees constitute at least 33% of your workforce, again, excluding part-time, you'd be subject to the WARN Act notice requirements if 75 or more employees and the layoff's going to last longer than 6 months. Or if you laid off at least 250 employees, excluding part-time. So again, 75 or more employees, you're subject to it. Mass layoff, longer than 6 months. You laid off 250 employees, you're subject to the WARN Act notice requirements. What about a plant closing? If the shutdown results in an employment loss at the single site of employment during any 30-day period, again, still has to be longer than 6 months, of 25 or more employees, excluding part-time, right? So this means you've completely shut down the plant, right? It is an empty facility. There's nobody there. You've completely shut it down. No one's working from home at all either. You've completely shut down facilities. If that is affected 25 or more employees, you are subject to the WARN Act notice requirements. Again, if you have 75 or more employees and you know that plant closing is going to last longer than 6 months. There is an exception to the notice, now to the time period in which you have to provide notice. Ordinarily, you have to provide employees at least 60 days notice of the layoff or the plant closing, right? Unless an exception applies. That exception, which we've been reading to be an exception, is if there's a physical calamity, right? We have been arguing that COVID-19 and what's going on with COVID-19 is in fact a physical calamity, such that our clients' employers were not required to provide 60 days notice. They're only to provide notice, give as much notice as soon as is practicable. So when you do give that notice, you have to identify, if you're not given 60 days, you have to identify in that notice to the employees and to the appropriate government officials why you didn't give 60 days notice, right? Should include a reason in there that based on COVID-19, based on the economic downturn, it wasn't until April 7, 2020 that we finally made the decision or understood and knew that we were going to have to close shop, right? So that's what you include in that notice. Next slide, please. So we have Cindy, 2 more slides here. Do you want to go through them or do you want to just take questions now?
I think these slides on OSHA are pretty self-explanatory. So for those that are still on the call, these will be included in the slides that we post on our resource page. And there were only 2 left. I think we should take questions. We have about 185 people left on the call.
So one thing I do want to make note of, if you can get to the next slide, which is not OSHA related, well, it's somewhat OSHA related, but it's not. So look at that second bullet point here, the social media bullet point. I just want to talk about that very briefly because that happened to a client of mine recently. So that's why I included this in here. So when Governor Pritzker came out with the shelter-in-place order, of course, they were essential or non-essential. My client chose incorrectly to say that it was an essential business, and they're not. And on Monday morning, an employee went on Facebook and completely blasted the employer. I mean, completely blasted this employer. Said who she worked for, said that this employer is essentially, they are misclassifying themselves as essential. They're non-essential. They're only doing this because they don't care about their workers. They don't want to shut down. They don't want to pay their workers. The workplace is just filthy. Just the worst things you can say about an employer, right? Needless to say, my client was not happy, called me and said, I think I can do this, but I want to terminate this person. I just need the green light. And unfortunately, I had to be the bearer of bad news to say, you can't terminate this person. Now, you can, but you subject yourself or discipline to an unfair labor practice charge. The reason is, under Section 7 of the National Labor Relations Act, and the National Labor Relations Act does apply to union and non-union employees. It says that if an employee has a right to engage in what's called protected concerted activity. And this means that I, as an employee, can discuss terms and conditions of employment, essentially any work-related reasons. If I talk about work-related reasons, you cannot, as an employer, take action against me. That employee who went on Facebook and blasted my client was discussing work-related reasons. That the workplace was a cesspool, that the employer didn't want to close, that the employer was too cheap, didn't want to pay the employees, talked about wages. Those are terms and conditions of employment, right? Those are work-related issues. When an employee talks about work-related issues, if you take action against that employee based on what they've said, and this could be social media where it happens all the time, you will subject yourself to an unfair labor practice charge. So I want everybody to be aware about that, because that situation is happening a lot, where our employees are going on social media and blasting us, and your hands are tied if they're talking about terms and conditions of employment. Okay.
All right. So Scott, with that explanation, and I'm glad that you did cover social media, because it leads into some other questions that have popped up that our participants may need some clarification on. Because of the shelter-in-place order has now been considered an isolation order and a quarantine order, how do our companies that are considered essential businesses manage that with their employees? If the employee says, hey, we have a shelter-in-place order, doesn't that override being an essential business?
It does not. If you're an essential business, you're an essential business, right? My client who said they're essential but not, they would be subject to that. Again, with all of that being said, based on what I said earlier. So if you're an essential business, you're open, right? And so long as you have work to perform, the employees are doing that work. Now, it could be a scenario, right, where you are an essential business, right? Manufacturing is essential. But you say, due to a lack of work, right, our non-exempt press machine workers, we don't have any work available for you, right? Our exempt folks, they're going to work from home. Your non-exempt press machine folks, because you have no work available for them to do, right? There has to be work available for them to do. You have no work available for those employees to do. They are not eligible under that shelter-in-place order, right? So you have to keep that in mind. Again, it's a confusing analysis, because it's, is there any work available for the person to do? If you've completely shut down, no work available, right? Completely shut down because you're non-essential, then the employees are not eligible, because the Department of Labor said there's no work for those employees to do because the employer is shut down due to the shelter-in-place order. The employer who is non-essential and who has work for the employee to do, well, that's a different analysis, right? But if you have no work for the employee to do based on their job, right, the press machine operator, and you're subject to the shelter-in-place order, or not subject to it, you're just sending the employee home because there's no work for them to do, that employee who there's no work for them to do, they are not eligible under that shelter-in-place order.
Okay. And you also mentioned, when you talked about social media, about a union as well as a non-union environment. For those that are in a union environment, does the CBA override any of these mandates, or do the mandates supersede the CBA?
You have to go by what's in the CBA.
Okay.
CBA governs.
Okay. Earlier when we were talking about emergency FMLA for an employee who has exhausted their regular FMLA, if an employer decides to give that employee the emergency FMLA because it is the right thing to do, and there's varying situations that could warrant that, can the employer still submit that for the tax credit? And under that scenario, would that still be eligible for the tax credit?
Yes, very good question. So I'll answer it broadly too, because it applies for any other reason. Even though an employee is not eligible, that does not mean that you as an employer cannot give the paid sick leave benefits under the emergency paid sick leave or FMLA. So I'm not eligible, but you still choose to give me the benefits. Yes, you can still claim the tax credit, so long as you have the appropriate documentation. So remember, for all of these reasons, under the employee, the paid sick leave, and the FMLA, it's not voluntary, but if you choose to give it to me, even though I'm not eligible, you can still claim the tax credits. Just make sure you're collecting the appropriate documentation. So the answer is yes, so long as you're maintaining the appropriate documentation.
Okay. For plants where there is a confirmed case of COVID-19 and the associated work crew from the infected individual needs to be quarantined for 14 days, are they eligible for emergency paid sick leave?
Again, it comes down to, one, they have to be eligible, but two, again, don't forget this reason, the unable to work or telework. So my response there is, do you have work available for that for those employees? Can they perform that work at home? If the answer is yes, they can, not eligible. If the answer is we have no work, we have work, but this person can't do it at home because they're the press machine operator, then the answer is no, not eligible. So don't forget of that additional analysis, right? Again, if you have work, they can do it at home. You have work, you permit them to do it at home, and they can do it at home, not eligible. If you have work available and they can't do it at home based on their position, right, not eligible. If they can't do it at home based on the COVID-19 related reason, right, I'm bedridden in a hospital, I'm unable to work, eligible. So, you have to make that distinction. Is it they're unable to do it because their position does not lend itself, right, to be able to work from home? Not eligible, right? If they're unable to work due to a COVID-19 related reason, I'm in a hospital bed, I cannot work, eligible because in fact I am unable to work.
Okay. If an employer is taking temperatures when employees show up for work, and if an employer can mandate that their employers wear masks in the workplace, one, do they need to provide the masks? And then two, if they send someone home, would that person then be eligible for the emergency paid sick leave?
Okay, so I'll take those. There's three parts to that question. One, my recommendation is you should not be taking folks' temperatures because there could be false positives. Also, if there is a false positive and you send someone home and they have absolutely no symptoms, and you are, in essence, you are regarding them as being disabled, right, potentially because COVID-19, that person can sue you under the ADA and say, false positive, I have absolutely no symptoms, I can work, my employer sent me home, they're not paying me, right, they are regarding me as being disabled based on this false positive. Now, other lawyers may differ on that. My recommendation, and not only that, but just because someone has a fever doesn't necessarily mean they have COVID-19 either. Someone may have a fever just because they have a fever. So I am telling employers, tread very carefully with that. Other lawyers may differ, but I'm telling folks, tread carefully. In fact, I would not be doing that for several reasons. What was the second part? Oh, the masks. Mm-hmm. I would provide the masks to the employees because where are they going to get it? I mean, no one has masks available. And in fact, my understanding is, because I was trying to get some over the weekend and called every single place that, every hardware, any, different place that has a mask, they're not getting them because they're all going toward our first responders and the healthcare providers. So if you want your employees to wear masks and you're mandating that, then the onus is on you, employer, to provide that mask. And what was the last part of that question, Cindy? If you send them home?
It was if you send them home, yeah. Are they eligible for leave? The emergency
again, we'll go back to the default of you have to meet all of the requirements. So, if you send someone home and they start experiencing symptoms and a doctor tells them to self-quarantine and that person is unable to work from home, so you have work available, right? And the person can perform it at home, but the doctor says when you're self-quarantined, you cannot work, eligible. If you send someone home and you have no work available due to their job, doesn't matter if they meet the 6 requirements, not eligible. So it's not as easy as saying, and again, you have to remember to include that other analysis in there, the able to unable, or the unable to work. It's not just do they meet the requirements of the emergency paid sick leave or FMLA. That's one part of the analysis. So that's why it's difficult for me to say, are they eligible? Because they may be if they have, if they meet one of the 6 requirements, but then we still have to determine, are they unable to work or telework due to a COVID-19 related reason?
All right. Next question. Okay. This will present a little bit of confusion during the presentation, Scott. For leave reason number 5, when they're taking leave, the employees taking leave are entitled to pay at 2/3 their regular rate or 2/3 the applicable minimum wage, whichever is higher. That was what's on the DOL website, but it was understood during the presentation that you said that it's the greater of 2/3 the regular rate or the applicable minimum wage, not 2/3 of the applicable minimum wage. Can you clarify that?
I don't recall saying that, but so let me clarify it. So it is for reason number 5, so reason number 4 through 6, and for FMLA. It is 2/3, the greater of 2/3 the applicable minimum wage. I'm sorry, the greater of 2/3 the regular rate of pay or the applicable minimum wage. So again, an example is this. If you're in Chicago and you're paying someone $13 an hour, and the employee is eligible for and qualifies for reason number 5, right? You're going to take $13 an hour times 2/3. That is going to be less than $13. You're going to end up paying that person $13 an hour. So does that clarify it? It is the greater of 2/3 the regular rate of pay or the applicable minimum wage. I hope, does that clarify it? Again, hopefully that example does clarify it. Again, you know, the default will be the minimum wage if you are paying close to the minimum wage, right? If you're paying $13 an hour and you take 2/3 of that 13, well, that's going to be less than 13, right? So the greater of the 2/3 of the regular rate is the applicable minimum wage. So you're going to have to pay that person the $13 an hour.
Okay. If somebody is returning to work because they were suspected of having COVID-19, they are now symptom-free. If the employer asks them to wear a mask upon returning to work, should they be asking that of all employees or just that particular one?
If you're going to, if someone is coming back who has self-quarantined for the required 14 days, and they provide a note to you, which you should require a note from their doctor releasing them to return to work, and you require that person still to wear a mask, know that, and you don't require anybody else to wear a mask, you could subject yourself to a claim of discrimination under the ADA, under that regarded as prong. So my response to this is apply that uniformly, right? Whoever comes back should wear a mask, not just the one person, right? So anybody who's in self-quarantine, if you want one person to wear a mask who's coming back, then you have to require everybody else who's coming back to wear a mask as well, right? So that's how I would handle that. You don't necessarily have to have your whole workforce wear them if you're just applying it to those folks who are returning from a self-quarantine period.
Okay. Next question. Are the small business exemptions the same for emergency paid sick leave and emergency FMLA?
Yes, the exact same. No difference.
Okay. All right. Next question. Bear with me for a second. We have quite a few here. Some of them are on topics we've already covered. You may have covered this, but for emergency pay sick leave, the employer cannot ask the employee to first use PTO, but for emergency FMLA, the employer can ask them to first use PTO. Is that correct?
Yes. So very good question. Yes, that is correct. Under the, and this just got changed as of Sunday. So under the Emergency Paid Sick Leave Act, we cannot require employees to exhaust their existing company-provided paid leave prior to them being eligible or us paying out. Under the FMLA portion, we can. Now, be very careful, though, because if you do that, then the rate of pay is different, right? So remember the example I said of the employee who's got one month of vacation leave, and they're using that. So ordinarily, just as we talked about, it's the greater of 2/3 the regular rate of pay or the applicable minimum wage. For the 4 weeks that you are requiring me to use my accrued vacation, you have to pay me at my normal regular rate of pay. So if my normal regular rate of pay is $18 an hour, for those 4 weeks for FMLA, you have to pay me $18 an hour. For the 8 other weeks, right, then it's 2/3 of $18.
Okay. All right, a couple different questions here. Again, going back to reason number 5. Just for clarification, if an employee has a spouse who is at home teleworking, is the employee ineligible for 2/3 payment under reason 5?
Yes. Because remember, there cannot be another co-spouse at home. So you're going to get employees telling you, but my wife is working. It does, again, unless you want to choose to give it to them, it does not matter. The wife, if the law as read says, if there is somebody else at home, so if the co-spouse is at home, both mom and dad are going to be at home, ineligible.
Okay, to follow up on that, if it's a multi-generational household, an employee with a child lives with the employee's parents, could the grandparent qualify to stay home from work so the direct parent can continue to work? And you're all in the same household?
Yes, because again, there is another suitable person. So a suitable person means another guardian, it means a grandparent. In fact, it means a friend, even a neighbor. So in a multi-generational household, if the employee lives with the parents and the parents are going to be home, right, and the parents aren't self-quarantined due to a COVID-19 related reason, then in that situation, you could deny that leave request because grandma and grandpa are at home.
Okay. Getting into the counting question when you're trying to determine if you're 50 or under or over, do you include out-of-state employees? Do you include out-of-the-country employees?
Yes, it's all your employees.
Okay. All right, good question. Okay, this is a question about tax credits. Can we not take the credit for health costs in the current period and later file for the credit?
Can you say that one more time?
Can we not take the credit for health costs in the current period and later file for the credit? I guess if they just want to postpone applying for it, it's kind of what I read into that question.
Yeah, that's how I'm reading it. I don't know the answer to that. I don't know the answer to that question, unfortunately. I can ask. There's colleagues of mine here who are handling that payroll protection portion. I don't know the answer to that.
Okay. All right. I know we're not getting into the CARES Act on this call, but this is related to the Families First Act. Can employers deny requests for Families First if the company has applied for the PPP under the CARES Act?
No. If the person's eligible, they're eligible. It doesn't matter if you are applying for the CARES Act. And in fact, the purpose for the CARES Act is to reimburse yourself for paying for the Families First. So, you know, if someone is eligible, again, you have to give it to them, right? And then, you know, you wouldn't have, if the Department of Labor sues you, you then would be subject to the lawsuit from the Department of Labor because you don't have that, I acted reasonably and in good faith, right? You wouldn't have that argument because if someone's eligible, what argument would you have to say, I didn't want to give it to them? So you'd be sued from the Department of Labor. So if someone is eligible, again, they meet all the requirements that we've talked about this morning, you have to give it to them. There is no discretionary type of, there isn't a discretionary decision.
All right. This question goes to reimbursements. If you have now employees who are teleworking, do you have to pay employees drive time and reimbursement mileage to go to the office to pick up and drop off paperwork if that's not normally what they do if they're now teleworking as opposed to being in the office?
No, you would not.
Okay. All right.
A very good question.
Mm-hmm. Okay, I think we kind of touched on this. If an employee has a doctor's direction for the employee to quarantine, but the reason is due to the concern for the employee's high-risk spouse, does the employee receive the 100% calculation due to self-quarantine, or the 2/3 calculation, because the concern is really with respect to the employee's spouse. We had similar questions to other members of the household too. Maybe it's a high-risk child. So we have had this question in a couple different forms.
Yeah, I've had that question a lot in the past couple of days too. So the scenario is this. The scenario is the employee goes to see a doctor. The employee, first of all, is not experiencing any symptoms whatsoever. And nor does the employee have an underlying condition that makes him susceptible. But the doctor says you should self-quarantine because your wife is pregnant, or you should self-quarantine because you have kids at home who are susceptible. Unfortunately, the answer is no, that employee is not eligible. In order for that employee to be eligible, we're talking about reason number 2 here. In order for qualifying reason number 2, in order for an individual to be eligible under qualifying reason number 2, remember, it's a 3-part analysis. The individual, the doctor must have told you to self-quarantine because, reason number 1, you in fact have COVID-19. Reason number 2, you are experiencing symptoms such that it is more probable that you have COVID-19. And then reason number 3, you have some underlying condition that makes you more susceptible. In that particular scenario, dad does not meet any of those requirements. And again, I've gotten that question a lot. So again, you can choose to, again, and claim the tax credits, and then if you're applying for the CARES Act payroll protection, you'll get all that reimbursed, right? You can choose to, but technically, dad is not eligible because dad's not experiencing symptoms, dad is not tested positive, nor does dad have an underlying condition that makes dad susceptible to COVID-19.
Okay, last question. And thank you all for staying on the call. We appreciate it, and we hope we have gotten to your questions. But here's the last one, Scott. There's an employee who's choosing to self-quarantine. We are requiring the employee to come to work. The employee can do some work from home, but not enough to work the full work week of 40 hours. What's your recommendation on how they handle that?
So again, if an individual is choosing to self-quarantine, they are not eligible, and I'm not sure if this is what the question is asking, but if I am choosing to self-quarantine and I don't have a doctor's note, I am not eligible for any benefits under the paid sick leave or the FMLA portion. I'm sorry, under the paid sick leave, not FMLA. In order for me to self-quarantine, I need a doctor's note. So if an employee says, I'm going to self-quarantine, and it's a non-exempt employee, you don't have to pay that person. In fact, you can say, for the period of time you self-quarantine, we're going to make you use your vacation time, right? And even if that employee applied for unemployment benefits, right, you should contest that. And how I've advising my clients to say, hey, this person has in essence resigned from their employment for these 2-week period of self-quarantine, right, for a reason not attributable to the employer. So there's various ways to handle that, but at the end of the day, if the question is that person eligible for benefits under the paid sick leave, the answer is a resounding no, because that person cannot choose to self-quarantine him or herself without a doctor telling them to do so.
Okay. All right. Well, Scott, first, I'd like to thank you for all of the detail and the thoroughness of this presentation. As I go through the questions that were submitted during the call, every theme has been touched on. For those of you that didn't get your specific question answered, we will be submitting that list to Scott, and he'll be supplying a written response, which we will then circulate to you. I would anticipate you'll be getting that within the next day or so. I'm sure he's quite overwhelmed with his own clients as well as helping us out here at the IMA. For the 135 of you that stayed on the call, we want to thank you for your attention to participating on this call and for submitting questions. Please look for the recording of this call and for the slides on the IMA COVID-19 resource page. That will be up within the next 24 hours as well. Scott, any final comments before we bring this to a conclusion?
A couple. So I would also, we have a Greensfelder, I know it's on, when you get my slide, it's the last slide. We have, just like the IMA does, an amazing resource page that is free to anybody. If you go to www.greensfelder.com, it's the first thing you'll see on our webpage. just click on that, and there are just an amazing amount of resources that we are updating hourly and by the minute, quite frankly, when new developments occur. The last thing is, there is no one one size fits all here, right? And I'm telling that to all my clients, where you may be getting a lot of general advice, but you've seen based on the questions we've had today, that general advice is not applicable when you add a little wrinkle into a particular hypothetical. So these are case-by-case scenarios that you have to handle as such, case-by-case scenarios. So be very careful about that.
All right. So with that, we are bringing this webinar to a conclusion. I'd like to thank the IMA team that is on the call that has provided the back office support so that we could bring you a comprehensive presentation. Scott, again, I cannot thank you enough for the time you've put into preparing this and the time you devoted for the entire morning today to present this information as well as take our members' questions. And again, to all of you, we will have this all posted on the IMA resource page within the next 24 hours. With that being said, thank you very much. For those of you that are members, pay attention to our daily emails. It will let you know of upcoming webinars. For those of you that aren't members and you want to be on our mailing list, please get your information through the IMA email address at ima-net.org. With that, we're bringing this to a close. Everyone stay healthy. Thank you.
Thank you.